Made to yourself. Well, this is an appeal not filed by the government. So the period already over. I beg to submit before your lordship that this may be fixed on 2nd, 22.
Second 22,
Yes,
22nd.
22nd.
All right.
All right.
It is just a moment. Division bench matter.
Yes.
What is the matter about? Just a moment. Just a moment. 2022. Friday.
Yes.
What is the urgency, Mister?
He already
Just-
got retired.
Just a moment. You are getting listed for what purpose? Order
Fine.
hearing,
For final hearing.
final hearing,
Yes.
not Friday. Next week. See, what was the last order passed?
Last pass was for I think 2 weeks. After 2
2
weeks,
weeks.
already over.
Just, I think it will come up next week. If it does not come up next week, you make a mention on Monday, all right?
Government will not mention because government is very happy that it will remain kept on pending for
See-
years together.
What is the matter about?
Service matter.
Promotion,
No, already got retirement.
retirement?
Yes.
See, if the matter is due for listing, it will come up. Maybe this week, maybe next week. If it does not come up, you make a mention on Monday. All right,
Actually, we actually asked before this court to expedite the matter. Because all matters are urgent.
let us take up today.
Yes, I am ready.
Okay, all right. Today we'll take
But
up.
government
All
report is not there. He is not ready.
So therefore, you have to take all aspects into account. Is not it? All aspects into account. See, if you, Friday, maybe only your case. Next week. You make a mention on Monday.
Please, your lordship, order item number 8, my lord.
8.
My lord,
Yes.
this matter may be adjourned for a week, my lord. Some instructions are available.
Okay, after a week.
Highly obliged.
Yes, my lord. My lord, I beg to mention item number 9.
9.
The matter may be listed after 4 weeks. my lord.
Okay, after 4 weeks.
Your lordship, we have to file rejoinder for that's one number 3.
Yes.
Rejoinder is ready, but we couldn't execute the affidavit, so maybe
On
given one.
prayer of Miss Sonam Somal under counsel for the petitioner listed after 4 weeks.
1 week.
Huh?
1 week.
2 weeks.
Much obliged.
Well, the objective of filing this writ petition has substantially been achieved. And I am happy that,
Influxes.
no, not infrastructures.
What do you want today?
Or first part, they have complied by constituting the state police complaint authority and the district police complaint authority. The second part is that separation of the investigating agency from the law and order duty. So which they were directed to furnish the list before this honorable court so that they can be sent to Judicial Academy for training. This aspect they have not done.
What is to be done today?
Let my brother Kapil say something on this.
Lordship, we have already notified. In our additional affidavit, we have already given also.
So repetition has become influxes. He's saying writ petition has become infructuous.
I say it is not infructuous.
Okay. What is the prayer made? What is the prayer made?
Just, there are two. First prayer is a writ of mandamus or such other appropriate writ or other directions. Directing the respondent number one to set up per se to constitute police complaint authority and to separate the investigating police from law and order police to ensure a speedier investigation in terms of law laid down by the Honorable Supreme Court of India in the case of Prakash Singh Subbramanian.
Okay,
The first part is they have complied,
all right. Police complaint authority has been set up.
set up both district.
Now, investigation wing has not been separated. It has not been separated.
Not been separated.
Yes, Tapi.
Kindly come to Lordship, my additional affidavit,
Additional affidavit.
page 13, Lordship. This additional affidavit was filed on Lordship 23rd March 2023, Lordship.
By respondent number 1 and 2.
Lordship, yes, Lordship, by one Jalas party, Lordship.
When it was filed?
23rd March 2023, Lordship.
How many additional affidavits you have filed?
I think 3-4 affidavits.
Like 3 affidavits, Tapil. 3. Which one you are referring to?
Okay, 23rd March, yes.
Okay. Kindly come to page 13, Lordship.
Yes,
Page 13, Lordship.
The bigger.
1-3, Lordship.
1, 3.
No. This is a Lordship notification, Lordship. Notifying the Lordship officials or investigating wing, Lordship. A committee was constituted, Lordship, a board, Lordship. And on their recommendation, Lordship, they have been notified, Lordship.
Yes. At page 13?
Yes,
They have separated.
they have separated, but they have appointed the officer from same police station.
Same police station.
Yes.
So it has to be from different police station.
They have to draw from the various wing of the Arunachal Pradesh Police, maybe APPBN or civil police or.
Let us see that in Prakash Singh, where it is given.
Paragraph 31 point,
They have to be drawn from different,
no, that is not there.
that is not there.
That is not there.
Then is it in compliance with the direction of the Prakash Singh Badal case?
Yes,
Then it has been complied with.
that's why it, now going by the affidavit, it appears.
Okay. Earlier you were submitting that it has not been complied with.
That was my tentative view.
Okay. So it has become infructuous.
Instead of infructuous, my lord will close this matter with an observation
On
that
the
the prayer of the prayer advance in the PIL has been complied with.
Mr. Tara Lamek, counsel for the petitioner, submits that the prayer made by the petitioner in the instant public interest litigation has been complied with by the respondent authorities. In that view of the matter, this PL stands closed.
Great.
All right.
Please, Your Honor.
My lord, as per the direction of this honorable court, district and session court has determined the juvenility of appellant. And it is found that he was juvenile at the time of commission of offense. So my prayer is setting aside of sentence imposed upon the appellant, and he may be released from custody. Appellant is convicted under section 302 of IPC for life imprisonment by the district and session court UPI in 13 March 2018.
Yes, what do you say?
Yes, Your Lordship, as per the age determination, the accused was found to be 17 years, 4 months and 19 days on the day when the offense is committed. So Your Lordship, so far as Your Lordship, the JJB Act is concerned, Your Lordship, if the juvenile accused is found to be juvenile, in that case, Your Lordship, since they are not challenging the conviction, while sustaining the conviction, Your Lordship, his sentence may be quashed, Your Lordship, because he has already in more than 3 years, because as per the JJB Act, a person can be sent to the special home or other place by the board for 3 years, not more than 3 years. So now perhaps he has already spent
More than 9 years.
more than 9 years, Your Lordship. And Your Lordship, in same situated case, Your Lordship, there is a direction from the Honorable Supreme Court, Your Lordship, the same observation.
Which one?
Your Lordship, Dharamveer versus State, Your Lordship, reported in 2010.
Where is the conviction and sentence? Different orders, I think.
In my petition, page number 14 is the conviction,
Page number 14.
yes, annexure 1.
Yes.
Operating parties in page number 34, Your Lordship.
Conviction and sentence has been by the same order.
No, Your Lordship, it's in 37 sentence, Your Lordship. Sentence hearing is required under section 235 to Your Lordship, in page number 37.
Page-
Okay, page 37. What is the sentence?
Sentence, Your Honor, imprisonment for life.
Page number?
Page number 34.
Huh?
Page number 34.
It is by the same order.
Yes, Your Honor. It's
The
the
same order,
sentence.
Your Lordship. In sentence, Your Lordship, he has admitted, Your Lordship. Sri so and so, you have been found guilty under so and so. Now you will be awarded sentence. What do you say regarding sentence? I admit and I have committed default. But I humbly pray to give me an opportunity to lead a new life, taking into consideration my young age. And page 38, your lordship, when the accused was forwarded to the jail superintendent, your lordship. In column 7, your lordship, it state the punishment and was sentenced to fully and distinctly, your lordship.
Okay.
What is the document we are subject to this one? That is birth certificate. Just produce one birth certificate, no? Class 10 certificate. School certificate. Patient. And this report is super. This is the report. This is the report. But examining the page, to put the signature in the document. That is super. The original is not here.
Have you gone through the order of the learned special judge determining the juvenility?
Yes, your lordship.
Has it been done in accordance with law?
Earlier, your lordship, it was not done in accordance
No,
with
no,
law.
see, earlier what the special judge did was class 10 pass certificate was produced.
Yes,
On that basis, he declared it as a juvenile.
yes, your lordship.
Then we found that the public prosecutor was not given opportunity. And we found that the juvenility was not determined in accordance with law.
Yes,
We sent back.
yes, your lordship.
Here, what the learned special court has done again is public prosecutor was provided an opportunity, and on the production of that same certificate,
Yes, your lordship.
the appellant has been declared as a juvenile.
Yes.
Do you think it has been done in accordance with law?
Your lordship, the state has not objected, your lordship.
This
This is-
PP has not. objected.
Yes, your lordship. If state has objected, then they have to lead evidence, your lordship.
Okay.
But PP has not objected. Here, the PP has admitted had accepted that the document is the original one on the basis of which.
Because that's what is, he was been convicted. So we have to include the money. He has already been convicted by the sessions court. It needs to include the matter, the sessions on the basis of the documents. So where is the documents? Documents that is not there. He is to examine the witness and then to send report whether he, on the basis of this full certificate, whether he was at that time given. Possibly was not. This is not. It's feasible matter. He has not up to duty, but at this case, he has also power to declare it. So the sessions of claims already completed and so that is doing is been convicted. At this stage, the sessions is to inform the matter on the basis of the document. What he is submitted before this. After examining the witness, whatever it is, that is the direction of this.
We'll post this next week. All right.
Okay, all right.
What do you have to say?
The number two.
Yes.
I'm not, here I'm a private respondent too, and I have no objection on the ground of juvenile. Your Honor.
Okay. We'll post it next week. All right. Card listed on Monday. Give the book.
Offline, Your Lordship.
Service report with respect of respondent to is still available.
On the last hearing, notice was to be issued to the respondent number 2, that is the victim. And I have also not received my paperwork.
All right. Miss,
This, Your Lordship, this is listed in admission column. I have made submission before this court on 13/6/2023. That 13/6/2023, I have made submission before this court that there is a delay in preparing appeal.
delay.
So in preparing appeal, delay by 4 years, 3 months. Accused are languishing in jail. They are. So now amicus has been appointed for appeal, because this is a jail appeal. Even in jail appeal, I have placed one judgment that was passed by the division bench of Jharkhand High Court, whereby the even jail appeal needs condemnations. I have placed that judgment before the court, and it's a part of my condemnation.
Yes, Dara.
On the next hearing, that is 18/7.
Condemnation application is there, I think.
Yes, it is there and it was allowed on 18/7/2023.
18/7.
Yes.
Sadhu?
Yes, it's not there condemnation.
IA number 26 of 2023.
I've not been punished with a copy, and I have not received it.
Was heard and allowed. There's a delay of 808 days.
Yes, we have condoned it. Oh, that day, Miss T. Gini was there.
Yes.
T. Gini was there. By 18/7/23 order passed in the IA, delay has been condoned.
reminder to the registry.
Heard S.P. Dharan. Learned amicus curiae for the applicant and Ms. G. Tado learned APP for the state. Office note dated 8/16/8/2020 indicates that the LCR has been received. So since the LCR has been received, registry directed to prepare the paperwork. In view of the await service report in respect of the respondent number 2 as indicated in office note dated 15/9/2023. Please state as and when the paperwork is prepared along with the service report of respondent number 2.
Most obliged.
May I receive on behalf of Peter Pug, C is out of the station.
On the prayer council for the applicant, IA is, what is this IA for?
For condonation of delay, your lordship.
Applicant listed after
4 weeks.
4 weeks.
Right, please, Lordship.
Yes.
So here, service report in respect of private respondent number 2 is still awaited.
Service report? Okay, heard Mr. K. Lawrence, learned counsel for the applicant.
Yes, applicant.
What is this IA for?
IS for condemnation, Lordship.
Okay,
There is a
and
delay of
Ms.
74.
L. Hage, learned APP for the state. Await service report of respondent number 2 is indicated in the OM office note dated 15/9/2023. In view of the above listed after 3 weeks with service report of respondent number 2.
Obliged.
Service not completed, your lordship, in favor of respondent number 2.
2.
Yes, your lordship.
And Mr. A.
Also
Amorphous
paper move.
Amorphous and Mr. T. Ete learned APP for the state representing the state. Who is respondent number 2
The mother, your lordship.
and 3?
Mother of the victims, your lordship. The PW3 has been impleted, your lordship. The prosecution witness is the mother of the victim, your lordship.
Who is 2? And who is 3?
2, your lordship, as per the record, your lordship, 2 as perhaps your lordship has died, your lordship, in the record. The report came earlier, your lordship.
Oh,
So here he has been substituted with the mother PW3.
await service report of respondent number 3 as indicated in office note dated 15/9/2023. So since the LCR has been received, she is directed to prepare a paperwork. List it as and when the paperwork is prepared along with the service report of respondent number 3.
Obliged, your lordship.
Lordship, in my
Hmm?
in my petition copy, there is no respondent number 3. It's only
No, it was subsequently impleted
Yes, yes,
then
by one of the order.
yes.
so it's
You check the record.
Yes, yes. Obliged, your lordship.
Lordship, we have received the instructions, 2 weeks time will be granted.
Miss R. Vasanand, government advocate, press for any granted 3 weeks time to file counter affidavit. List it after 4 weeks.
Obliged.
At this stage, in item number, item number 12, I'll not press, this is out of the same common judgment and order passed by.
You will not press item number 12.
12, the item number 11 will cover,
Okay. Then we can dispose of item number 12.
However, that will be the subject to the outcome of the item number 11.
Okay, all right.
It is common judgment and order, arising out of the same common.
All
Admittedly,
This item has also bearing in the first item, my lord.
yes,
First item,
What he has submitted, then he will not press them, my lord.
item 12.
Item 12.
what if in this case?
This has some bearing in the WA 41, my lord.
Okay.
Because it's the genesis of the, my lord, those writ petitions, my lord.
Whatever in this case, admittedly, my lord, now by this proceedings, exactly hitting the target, altogether round around, my lord, without the touching the crux of the case, my lord.
Will to the touch the crux.
Admittedly,
Will not go round and round.
my lord, admittedly, as we have learned that life of law is not logic, the full of experience, my lord. From this experience, my lord, it is clearly demonstrated in this present case also, my lord. It is seen that, my lord, in all the proceedings, my lord, it is not as per the procedure and not as per the procedure established by law, my lord. That is the exact case in this present appeal. Now, my lord, this appeal has been prepared by the Union of India, my lord, and including the ITBP, my lord. And my lord, being agreed by the order passed by the learned single bench, wherein, my lord, certain my lord, the things which has not been taken into considerations, though it is in the pleaded case of the petitioner as well as the state respondent, my lord. When the ITBP was introduced and inducted in the state of Arunachal Pradesh, for bordering the state of Arunachal Pradesh and protecting the border area, my lord, the ITBP was inducted in the state of Arunachal Pradesh in the year 2005, my lord. And while inducting, my lord, the ITBP in the state of Arunachal Pradesh, earlier, admittedly, my lord, ITBP was not in the state of Arunachal Pradesh. It was Assam Rifle, my lord, bordering the Assam, my lord, boundary, my lord. And 2005, my lord, this altogether piece of land was initially in the possession of the Assam Rifle, my lord. And this particular piece of land was taken over by the ITBP from the Assam Rifle. And in the same year, 2005, thereafter, my lord, the ITBP, well, there is further procedure since it has been taken from the Assam Rifle, the another, my lord, organizations under the Ministry of Defense, my lord. The process was initiated for the transfer of the land. Well, precisely, may I take your lordships to Annexure 1, page number, my lord, of my writ appeal, my lord, page number 60. Straight away, I'll come to Madam Annexure. The Annexure 1. This has been written to them, my lord, the Commandant 9 BN ITBP, Ministry of Home Affairs, my lord. And it was written in the year 4th January 2008, my lord. After 3 years. Page number 60, my lord.
60.
60, my lord. Type copy is 61, my lord. 61.
Yeah.
It is more legible, my lord. Type copy. To the Commandant 9 BN ITBP, MHA, Government of India, so and so.
The payment of my lord, particular subject matter is payment of one-time land value at Dibang Valley district, my lord. That is
Yes.
written, my lord. Letter number so and so, so and so. Sir, with reference to the letter number dated cited above, you are hereby requested to deposit the land revenue amounting Rs 1,71,955 rupees only for 17,195 square meters at the rate of 10% per square meter of lane through Treasury Salon under head of account number so and so, addressed to the Director of Land Management and Government of Arunachal Pradesh, Itanagar, and a copy of the Treasury Salon may be submitted to the office of the undersigned at the earliest for issuance of the allotment order, my lord. This has been written by the concerned Deputy Commissioner where particular piece of land is located, my lord. By virtue of the collector, by virtue of the district administration, he has written this letter to the ITBP for one-time payment, my lord. Specific word is one-time payment, my lord. And after that, my lord, again, it was not acted upon. Thereafter, again, the altogether, my lord, the same, the next page number 63, 64, these all are, my lord, the same letter. It is in pertaining to a different location, my lord, altogether 4 location, my lord. First one is MIPI, lordship has already seen. It is in respect of MIPI, my lord. And the second one, page number 62, is, my lord, follow me.
Different plots of land are there.
Yes,
How many plots?
4, altogether 4 plots.
4 plots.
Therefore, my lord, separate later, it is in respect of MIPI, first one. Second one is, my lord, Anini. Third one is Anini. And fourth one is Malinie, my lord, page number 64. And my lord, and the fifth one is Dambian, my lord, page number 66, my lord. And the fifth one is, my lord, same type copy. And the seventh one is page number 68, the same annexure 1 colli, Italian, my lord. And the type copy is, my lord, specific location has been mentioned, my lord. And almost, my lord, the rates are different. But sorry, it's same, but the area is different, my lord. Per square meter at the rate of 10 rupees per square meter, my lord. And my lord, the last part, may I take your lordships to again page number 70, my lord.
But in the letter, name of the plot is not mentioned.
My lord, therefore, in particular, my lord, just head of the letter, my lord, may I read again, my lord? Just
Head of
for a
the
moment,
letter.
may I take your lordships to page number 68?
No,
Page number
you-
68.
You come to 60.
My lord, 60 is
You
MIPI,
begin-
my lord. By handwriting, my lord, it is written, my lord, MIPI.
Where?
Subject matter, my lord, payment of one-time settlement value at, by handwriting, my lord, it has been built up.
Payment of one-time land value at Dibang Valley district, MIPI.
Yes, my lord.
This is for MIPI.
MIPI, this is for MIPI, my lord.
Okay.
And the second one is page number 62. Page number
Anini.
61 is the type copy of the same number, same page number 60. 62 is Anini, my lord.
Okay.
And the same type copy, 63. And the 64 is Malinie, my lord.
Anini can't be a plot.
And then within Anini, it is called place.
MIPI is also name of a place.
Yes, my lord.
Okay.
And the third one is
Malini is also name of a place.
correct, my lord. Area, village, or my lord, exactly. I haven't been
All right.
there.
All right. Oh, okay. Yes.
And pursuant to that letter, my lord, the commandant, my lord, he has written a letter to the deputy commissioner, my lord, conveying the message that my lord, may I take your lordship specifically to your lordship at page number 70, my lord.
Yes.
This is written to the deputy commissioner, Upper Dibang Valley, Anini, so and so on. I am directed to say that the Assam Rifle was in occupation of the land at the following borders outpost since 1950, and above land has have been handed over to the ITBP force in 2005 as per MHA order, serial number, my lord. These are the particular, my lord, written, my lord. Earlier it was written as piecemeal, my lord, but this is in altogether, my lord, all the floors has been mentioned, my lord.
6.
Since 1950, my lord. And the, my lord, same serial number, my lord, lordship will find at serial number 1, Anini, 2, Amalinian, 3, Dambian, and 4, Mipi. My lord, Italian is another subject matter, my lord. Here, Italian proceeding is not, my lord, included. Malini, my lord. And the respective, my lord, total area is also given, my lord. The year of, my lord, occupation is also given, my lord. It is 1955, 59, 59, 59, my lord, 1959, 1959, my lord. Serial number 2, my lord. Your honor is therefore requested to carry out the survey of the length in occupations of the ITBP now at the above places and the transfer names in the name of ITBP force, the Ministry of Home Affairs under the provisions of the State of Arunachal Pradesh Act 1960, as these lengths have earlier transferred in the name of the Assam Rifle under above provisions without any cost. Hence, case of the exemptions on the payments of the one-time length value may be taken up with the concerned authority at the earliest, and the land may be transferred in the name of the ITBP force. Early action in this regards will be highly appreciated, madam. This has been written by the ITBP to the the concerned deputy commissioner, madam. And next page, madam. Madam, this is also correspondence made to the ITBP by the concerned deputy commissioner, madam. It is again in respect of the post commandant, it is in the separate letter has been issued in respect of the separate location, madam.
Which one?
Page number 71. This is for MIP. 72 is for Anini.
This is again for payment of a
One-time settlement, madam.
one-time settlement.
Yes, madam. With refer, the one-time payment of land settlement. The whole proceedings was initiated by the deputy commissioner as well as the representative of the ITBP for
No.
one-time settlement, madam.
Not settlement, land revenue.
Land revenue, madam.
One-time payment of land revenue.
Exactly, madam.
Yes. Yes.
And madam, rest I'll skip. This is all same letter, madam. Up to page number 171 to page number 75. This is in respect of madam separate land, madam. Now, madam, in response to the letter received from the concerned deputy commissioner, the concerned the ITBP, who is in the location, madam, it is 9 BN particularly, madam. He has written a letter to the concerned higher authorities for the payment of the one-time land revenue of BOPs, madam. 9 BN, madam. It is also given, madam. Same, madam, altogether, madam. This how this is important, madam, is because all the proceeding was for payment of the one-time land revenue. It is it was written on 4th August 2012, madam.
What is this letter?
By this letter, my lord, we have proposed for the sanctions of the amount which to the tune of 18,85,015 rupees, my lord. This is the same location, including Italian. As I pointed out, serial number 6 is not included in this proceeding, and this is for payment of sanction and payment. This has been written to the higher authorities, Deputy Inspector General.
For payment of land revenue.
Release, it ultimately it has to be released by the Ministry of Defense,
All right. This is your internal communication.
Yes, internal
Yes.
communication. Exactly.
Yes.
And the sanction has been, accordingly, on the initiation of the concerned deputy commissioner, all correspondence was made, and this ITBP has written to the higher authorities for the sanction and the release of the amount. Accordingly, the sanction was granted. Sanction order is at page number 78,
Yes.
It was sanctioned on the 5th February 2016, sanction order, by the ministry, As per the Ministry of Home Affairs, letter number so and so dated, the use of the financial delegations power 9 BN gives the administrative approvals and the financial sanctions of Rs 18,78,690 under head of the account so and so, fund so and so, for transfer of the land of following forward post under 9 BN ITBP, my lord. Same, my lord, serial number 1, same location, my lord, Anini, Dambian, Mipi, Alinie, Malinie, my lord, Italian also mentioned, but it is in not the present proceeding, my lord, not included in the present proceeding. It is certified that the said land is necessary and obligatory, my lord. It is certified then the payments of the above the amounts will be paid through the state government revenue department. The fulfillment of this expenditure, I don't know, this is the other procedure, my lord. I'll skip. This is the important, my lord. But the important is, my lord, the sanction has been granted, released, my lord, by the Ministry of Home Affairs, my lord, Ministry and of Defense also, my lord, is in respect of the payment of the, my lord, one-time, my lord, payment of the revenue, my lord, in respect of this particular piece of land. And my lord, page number 79. This has been communication again made to the Deputy Commissioner regarding the, my lord, issue of the allotment order, married man. Subject regarding the issue of the land, the allotment order of the BOP lands in Dibang Valley district.
What is BOP?
BOP, my lord,
Border outpost.
my outpost, my lord, I'm sorry. Border. Kindly refer to your letter number so and so, dated so and so, regarding the one-time payment of the land revenue for the forward cost of the 9 ITBP, 9 BN ITBP in Dibang Valley at Anini, Dambian, Malinie, Aline, Maline, and Italy. As per your order demand note so and so, dated so and so, for the above mentioned location, it is intimated that the sanction has been received from the ITBP Directorate General for RS 18,78,690. The amount is likely to be submitted by second week of April 2016. Hence, you are requested to direct quarter concerns to complete the formalities of the allotment orders and prepare demarcations made, possession certificate, and NOC of the above mentioned location land. After the receipt of the sanction amount, this communication has been made for the initiation of the, the transfer, issuance of the allotment order.
Yes.
And the next phase, page number 80, same communication. Deputy Commissioner, it is written to the Deputy Commissioner regarding issue of allotment order of the BOPs, lane in Dibang Valley, Anini. Same, almost the same thing,
So you are deposited revenue.
So far, my lord, we have not been allowed to deposit, my lord, as because the subsequently this proceeding has come up.
All right.
My lord, when the, my lord, under process for the deposition of the sanction amount, my lord, all of a sudden, my lord, private respondent has moved this honorable court by of writ petition, bunch of writ petition, my lord. I'll come to that part also.
All right.
My lord, next page, page number 81.
Yes.
This is also the same correspondence, my lord, regarding the, my lord, the type copy is page number 82, my lord.
Yes.
I'll skip this all are, my lord, same things, narrating everything, my lord, history of the, my lord, and the background of the, my lord, the land. This, my lord, last page number 83, my lord.
Yes.
Despite of above correspondence and the meetings with you by our unit officers at Anini, until unit not receive any response regarding the issue allotment order concurrence for the depositing sanction amount in treasury, my lord. This is the last correspondence, my lord, by which, my lord, the communication has been made. My lord, sanction has been already granted, my lord, allow us to deposit the amount. And hence you are requested again to take the amount for the land at the various locations as above mentioned and the issue allotment order as early as possible. Madam, this is the last correspondence made by the ITBP to the Deputy Commissioner, madam. Madam, same, almost same correspondence, same subject matter, but different letter. Page number 84, madam. It was on 24 June 2016. Page number, my lord, 85, my lord, the relevant portion, my lord. Hence, you are requested to direct DC, my lord. This letter has been written to the Director Land Management, my lord. Page number, my lord, 85. Hence you are requested to direct the DC Anini for take amount for the land at the various locations as above mentioned and issue allotment order. Well, in fact, we are writing letter to the concerned authorities for the issuance of the land allotment order, man.
Yes.
But that has not been taken place. Again, my lord, the ITBP letter, my lord, page number 86 is, my lord, letter written by the director to the deputy commissioner, madam. Allotment of land for ITBP, BN 9 BN ITBP, madam. I am directed to forward here with a letter received from the commandant 9 BN ITBP police regarding the allotment of the lane to the BN ITBP police for the establishment of the BOP in Dibang Valley district, which is self-explanatory for taking further necessary actions from N, please. But no action, my lord, from the deputy commissioner. Ultimately, my lord, the allotment has to be initiated by the concerned deputy commissioner, and the same has to be forwarded to the concerned, my lord, the director land management for approval. And my lord, again, second in command written a letter to the, my lord, the deputy commissioner on 26 August 2016, man. Same thing, man. This all of the correspondence made to the deputy commissioner. And my lord, this is another, my lord, the correspondence, my lord. Just may I take your lordships to page number, my lord, all together same, my lord, page number 89. 86 is the, my lord, the first letter written to the director land management, government of Arunachal Pradesh regarding to one-time payment of the land revenue of allotment lane and issuing the allotment order for ITBP BN in Dibang Valley. So same location, madam. Last part, madam. Page number 89. You are therefore earnestly requested to issue directions to the deputy commissioner Anini to deposit the sanction amount for making the payment of the land revenue for the aforementioned the BOP's location, and positive and early actions will be highly appreciated, madam. This has been written by the the ITBP to the the concerned authorities. Till now, all correspondence has been made for to the ITBP, the concerned department as well as the government. No action.
Deputy commissioner not accepting your revenue.
Correct, man.
Okay.
After initiation was done by the deputy commissioner himself for the payment of the amount. Accordingly, we get sanction from the ministry, and when we are about to deposit the amount, he has not accepted. And the next, next later. This is internal later. We'll skip this page number 92, madam. And the page number 93, again written to the deputy commissioner by the ITBP, 17 March 2017, madam. Same language, my lord, almost same thing, my lord.
Yes.
Paragraph, my lord, page number 94. Page number, married, my lord. Paragraph 6. Refer Director of Land Management, letter number so and so, Secretary of the Land Management, Itanagar, so and so letter, byte number so. You are directed to take necessary action for allotment of land to 9 BN ITBP, and your personal initiatives was asked for to sort out the pending issues of the land at the earliest respectively, madam. Hence, you are requested to deposit the amount for rest of the BOPs as mentioned above and issue allotment order in the name of 9 BN ITBP. My lord, this correspondence has been made by the ITBP, my lord, for necessary action, my lord. Again, it was not done. My lord, all are same correspondence made to the deputy commissioner, my lord. Page number, my lord, 96 also correspondence made to the, my lord, deputy commissioner by the ITBP. And the page number, my lord, 98 is also the same letter made written to the deputy commissioner, my lord. And my lord, While this process was initiated and the correspondence was made between the the department and the ITBP and the government, all of a sudden, this writ petition, WPC number, 11 of 2017 was moved before this honorable court, page number, 104, annexure 4, series, This is one of the documents and the judicial order passed by this honorable court, wherein it has been specifically given directions to the concerned deputy commissioner. But that has not been done by as per this order. Page number 104 is the starting, and page number 105, page number 106. May I take your lordships to the lordship from the page number paragraph third, fourth paragraph, in such view of page number 106. In such view of the matter, this writ petition is disposed of with a direction that the deputy commissioner, Dibang Bailey, would cause an inquiry and ascertain as to whether the land in question involved in this writ petition is a community land of the writ petitioner or is a government land. In causing the inquiry, the deputy commissioner would also consult the land revenue record pertaining to the land from prior to 1955. It is stated that earlier this plot of land was a part of the erstwhile Lohit district, and after the bifurcations, now it is part of the Lower Dibang Valley district. In view of the matter, deputy commissioner, if requires, may also requisitions the land record that may be available in the office of the deputy commissioner, Lohit districts, to arrive at a proper assessment regarding the ownership of the land. While conducting the inquiry, the deputy commissioner will also give the writ petitioners or his representative an appropriate opportunity of hearing in order to present his case that this land is a community land of the writ petitioner. While giving the opportunity, the deputy commissioner would also allow the writ petitioners to provide any evidence and the material that they desires to produce in order to establish the claims that this land is a community land of the petitioner. The aforesaid exercise be carried out within a period of 6 months from the date of the receipt of a certified copy of this order, till such decision is arrived at by the deputy commissioner and a finding is made that this land belongs to the government land. The further proceedings pursuant to the letter dated so and so of the deputy commissioner, so and so district of the ITBP shall not be proceeded. That was for regarding payment of the deposit of the amount. From this record, by order of this honorable court, it is clear.
This order is relevant for adjudication of this appeal.
Exactly, it is relevant,
Relevant.
it is one of our ground that by as per this decision, now land has not been till date identified. It is whether government land or a private land, community land, that has not been identified. But what we are pointing is this land, piece of land has been taken from the Assam Rifle. However, this writ petitioner has moved this honorable court for a verification of the land. It has to be first of all determined. It has to be caused an inquiry. By inquiry, if it is established that yes, this is a government land, we don't have to pay any compensations to the persons who is concerned about this in the writ petition. And if it is government land, the only one time is we have made correspondence.
Okay, we will proceed further.
My lord.
What we have noticed here is this.
My lord.
By this order, you are investing the deputy commissioner a judicial power.
Admittedly, my lord, by this order, my lord, it has been, somehow direction has been given to the deputy commissioner.
How the deputy commissioner will adjudicate the ownership of the land?
My lord, admittedly, by virtue of the deputy commissioner, my lord,
Anyway,
after-
we'll
it has to
proceed.
be, it has to be, my lord, determined, it has to be cause inquiry, my lord. After causing inquiry, my lord, at least that will be established who is the owner of the real owner of the land.
Deputy commissioner will determine title.
Not exactly, it is titled, my lord, cause
By
inquiry,
the-
my lord.
When this order was passed,
My lord, if I,
civil court of competent jurisdiction was already there.
my lord, I am not disputing this part, my lord.
Yes.
What I wanted to point it out is this, at least deputy commissioner has to cause an inquiry just to ascertain who is the real owner of the land, my lord. That inquiry is a, my lord,
That
the
inquiry is what? Determining the title of the land.
title is one thing, my lord, the ownership, my lord, at least ownership.
Okay, ownership.
Who is the
Alright,
owner, real owner? My lord.
alright. Yes.
And my lord, page, next page, my lord, 108, page number, the repetition number, my lord, 774 of same year, my lord, 2017. Altogether, my lord, same direction, same, my lord, the, my lord, party, my lord. Sorry, my lord, same, different petitioner, but the subject matter is same, but the location is same, my lord. And page number, my lord, it comes to page number, up to page number, my lord, page number, my lord, 131,
Who is Gita Mehu?
my lord.
Who is Gita Mehu? Gita Mehu is a respondent here.
Yes, my lord.
Anam Mepi,
Yes, my lord.
respondent. Yes.
I'm sorry, my lord. Gita Mehu is not the party, my lord. I'm sorry. Yakuli Mipi, Ganga Mili, Sipa Melo, my lord.
So the order you are referred to was in the Gita Mehu's case.
Exactly, my lord.
Then
But in Gita Mehu case, my lord, why we are pointing is, my lord, in Gita Mehu case, admittedly, single out case wherein Deputy Commissioner has caused an inquiry, and by inquiry, my lord, it has been established that this piece of land belongs to, my lord, a government land. That inquiry was caused, my lord. My lord, we don't know how this particular piece of land has been excluded, my lord. But in Gita Mehu case, it is admittedly, my lord, Deputy Commissioner has caused an inquiry. After causing the inquiry, my lord, it has been established that this piece of land belongs to a government land, my lord. And the Gita Mehu against that decision passed by the my lord, Deputy Commissioner, by which, my lord, inquiry was closed and the order was passed. He has moved, again, he has impugned that, my lord, the findings of the Deputy Commissioner. I think
let us proceed with the case.
my lord, that
You tell us what we are required to decide.
my lord, required to decide is, my lord, as we have already pointed out, they are not the owner, my lord, they are not the, my lord, no, my lord, admittedly, precisely, my lord, our pleaded case is, my lord, we have nowhere, my lord, initiated for the acquisition of this piece of land. My lord, as per the procedure, my lord, is contemplated under Rule 3 of the, my lord, the right to pay compensation, my lord.
Mr. Kato,
My
you are arguing an appeal,
Yes,
not a writ petition.
my lord, that is our pleaded case in the also.
Okay. Yeah.
And my lord, as we have already seen, the past, without, my lord, page number, my lord, 133, my lord. This is the past draft notice, my lord. My lord has already seen that all correspondence was for payment of the, my lord, one-time settlement, my lord.
I can see, we can see 4 or 5 other orders of this court passed in various other writ petitions.
My lord,
Which you
that
have
is
not,
the same, my lord, direction as I pointed, my
which
lord.
you have not referred to.
My lord, I have referred, my lord, I'll give same direction, my lord. Last part, my lord, page number, my lord, the last writ petition, my lord, is at page number, my lord, 132.
Okay.
My lord, all are same, similar direction, my lord. For causing inquiry only, my lord. That has not been done, but except in Gita Mehu, as I pointed out, my lord, in Gita Mehu case, inquiry was closed, my lord, findings and the result was, my lord, this piece of land belongs to the government land. And my lord, first, as I pointed out, my lord, page number 33, this is the first draft notification, my lord, sent by the Deputy Commissioner to the Secretary Land Management, my lord. Regarding draft notification under section 48 of the So-and-so Act 2013 for the land acquisitions by ITBP at Mipi, Tibang Valley District, my lord. This is in respect of particular piece of land, my lord. With reference to the subject cited above, the please find enclosed here with a draft notification the inviting the claims and objections from all the concerns under section 48 of the so and so Act 2013 for acquisitions of the land at the MIP so and so for acquisition. Well, this is the first draft notification. This has not been taken, published, of course, madam. And the second draft notification, first draft, same draft notification, madam, enclosed, page number 134, madam, wherein madam specific location is given, madam. And the page number 31, 35, madam. First draft notification. It was under section 40, madam, of the section 40 of the madam, urgency clause. And the second, same madam, draft that has not been published, of course. Madam, specifically, may I take your lordships to page number 137. Married, madam. Madam Deputy Commissioner, when the draft notification was forwarded to the Secretary Land Management for publications, the Secretary Land Management, in response to that letter, what he has written is very important, madam. With reference to the letter number so and so, page number 137, I'm reading one. Subject cited above, I am to inform you that a proposed forwarded by you for acquisitions of the land of the ITBP at Dibang Valley district is not accompanied with the following relevant documents. This is very important. Serial number 1, history of alignment plan approved by signed by the concerned district administration. There was no such that was the shortage. And the beneficiary list, that is also not forwarded along with the draft notification. And the details of the land and the assets calculation. And the detail serial number 4. Serial number 4, consent / willingness letter from requiring agency. This is one of our pleaded case. Without consent, without willingness certificates issued by the requiring agency, how notification has been published by the district administration as well as by the state respondent. This is the minimum procedure which has to be at least complied with by followed for acquisition of the piece of land. This is the first observations made by the Director Land Management, wherein it has been specifically mentioned that willingness certificate has to be at least obtained. As of now, we have not given any willingness certificate for the acquisition of this piece of land. And approved rate also, in rate also we are disputing, And the next page, 138. Written to the Deputy Commissioner by the ITBP on 9th August 2017. Sorry, 19 August. Kindly refer this office letter number so and so dated so and so regarding the issue of the allotment order of Aneni Amalini Alieni Dambian Italian MIP land in the name of the client BN ITBP. Refer your office letter number so and so by this letter draft notifications of the MIP so and so land has been sent to the Secretary Land Management, Government of Arunachal. But after lapse of the considerable time, no further progress is initiated by your good office till date. They also refer Director Land Management, Government of Arunachal Pradesh letter number so and so dated so and so regarding the examining the status of the pending land issue of the ITBP in this regard. Hence, you are again requested to speed up the process on this issue and the land allotment order of so and so land in the name of 9 ITBP may kindly be issued as at earliest. This has been written to the Deputy Commissioner. Same thing, page number 139. And the 9, page number 40. This is very important, it is well known to the deputy commissioner, it is well known to the other respondent authorities that willingness certificate was not given by the ITBP for acquisition of this piece of land, my lord. This was written by the deputy commissioners to the commandant ITBP, my lord, on 18 December 2017, my lord. May I read, my lord? This is important document, my lord. Regarding the urgent requirement of willingness certificate written pertaining to land acquisitions for the ITBP in Dibang Valley district, Arunachal Pradesh, and the payment of the compensation thereof. And then I'll skip first paragraph and referred case. With reference to the subject cited above and our correspondence pertaining to the expediting the land acquisitions for the ITBP land Dibang Valley, so and so, draft notification regarding this matter was forwarded to the Secretary Land Management. However, the draft notification was returned to us citing the relevant documents were missing. A willingness certificate is hereby required from the user agency. The copy of the letter is enclosed herewith for your reference. Therefore, you are requested to furnish a willingness certificate regarding the acquisitions of the BOFs land at Dambie, Malinie, Italian, Namipi in order to expedite the acquisitions and the process for the process of the payment of compensations to the land owners. By this letter, it is admittedly, my lord, so far, no willingness certificate has been, my lord, obtained or given by the ITBP to the concerned administration. Well, the rest of internet correspondence, my lord, I'll skip rest part. Same thing, we tried to verify the entire piece of land, my lord, and this is official correspondence, my lord. I will skip this part, my lord. Now, may I take your lordship too? Second draft notification, my lord. Without fully filling the condition precedent for the publications of the notification, another again they made an attempt to publish the another notification, my lord, is at page number 154, my lord. Second draft notification. This was also not published, my lord. 154, my lord. Notification, my lord, no date, nothing, my lord, only 2018, my lord. In fact, this was draft, therefore everything is not mentioned, my lord. However, my lord, location is mentioned, my lord. Area is also my lord, mentioned. And my lord, page number 163, my lord, the same thing, my lord. Deputy Commissioner has written to the ITBP, by which later, my lord, they sought for the furnishing of the willingness certificate, my lord. I'll skip rest part. It was written on 31st March 2018. Second part, my lord, I'll skip my lord, rest part so as to my lord, save the time of the court. Paragraph 2. And earlier, your office had requested to our unit by number so and so, letter number so and so, to submit willingness certificate to the Deputy Commissioner Anini for acquisitions of the above said land. But without further intimations to this unit and without submission of this willingness certificate, madam, this is very important, madam. This is the crux of the case, madam.
Page number?
Page number 156, madam.
156.
156. I am reading 156. I'm sorry, madam.
Yes.
Paragraph, second paragraph, madam.
Hmm.
It was written on 31st March 2018, madam.
Okay.
And earlier, your office number so and so requested to our unit number by letter number so and so dated to submit willingness certificate to the Deputy Commissioner and any for acquisition of the above said land. But without further intimations to this unit and without submission of the willingness certificate from the 9 BN ITBP, your office has issued draft notifications for acquisition of land. Therefore, it is requested that these notifications may be cancelled immediately, madam. We have written a letter to the Deputy Commissioner, madam, how come the without willingness, there being any willingness certificate is contemplated under the rules. Madam, publication of the draft notification is not tenable at all.
Yes.
Madam, Lordship has already seen that so far the correspondence is made for the payment of the sanction amount. correspondence was made for the publication of the certain documents, the shortage of the documents, and the requirement of the user agency for the furnishing of the willingness certificate. That has not been taken into consideration. That has not been done. All of a sudden, this impute notification, page number 166 is the impute notification published by the respondent authorities. None of the documents is sought for by the land management department has been complied with. Without fulfilling the documents, this notification all of a sudden has been published. This is the impute notification, page number 166.
Okay. Yes.
It was published on 24 April 2018. Specific land is also described in the CEDAL. All are in the district of Dibang Valley. Area is serial number 1, 2, 3, and 4. Alinea 1, Tampian 2, and 4 is Malinea. 5 is not given, MIPI. Now, by this notification, as I have pointed out, sanction was granted for altogether 5 pieces of land. But in this notification, only 4 pieces of land has been notified. Thereafter, we don't know how this has been initiated. It is our pleaded case without there being any willingness, without there being any certain things which is required to be fulfilled by the ITBP as well as by the district administration. This impute notification has been published. And we have written a letter after this notification. Again, we have written to the ITBP, Deputy Commissioner, page number, next page, this is page number 169. This part I'll skip, Page number 170 is the Hindi, in Hindi, and translated copy is page number 172, It was written on 17/7/2018, Director so and so regarding the proposal, And we are also making the internal communication by which
No, you said that after this notification at page 166 was published, you had written to Deputy Commissioner. What is that?
Deputy Commissioner. Page number 1. Translated copy is 183, 180. It is in Hindi, but page it starts from page number 180, but translated copy is 183,
183.
Yes.
This is to the Deputy Inspector General.
So, I'm sorry, page number 185,
185.
Yes, ma'am. $185 as well as the one. I'll come to the rest.
185 is a letter not in response to the notification dated 24th April 2018.
This is the first objection which we have raised regarding the rate.
This objection is your usual objection, which you have been raising from the day one. Issue allotment order.
No.
You said that after this page 166 notification was out.
May read the contents of the letter.
Yes.
We read specifically. This is the first objection after publication of the impute notification regarding the rate.
Where is the reference of that notification? 24 April 2018.
As I have pointed out.
Unless you refer to that.
As I have pointed out.
This objection, whatever you write,
yes,
will not be considered in pursuance to the notification.
May kindly appreciate one thing. The notification has been published by the Director Land Management. without in consultations with the ITBP.
See,
That
the-
notification has
not-
been,
Not the Director of Land Management. It was published by the Secretary Land
sorry,
Management,
Secretary Land Management.
saying that if anybody has any objection, you submit it to the Deputy Commissioner.
Admittedly, when we are not in a position to the giving.
Order, proceed.
My lord.
There is no any such objection pursuant to this. Though you have lot many objections,
Correct, my lord.
but there is no objection written by you after this notification dated 24th April 2018 was out. Okay,
Madam.
yes.
My lord, I'm on page number 155, my lord.
155.
Sorry, 185, sorry,
Yes.
185.
Hmm.
I'm sorry. Kindly refer to your letter of your office letter number so and so dated March, the land acquisition award so and so regarding the estimate proposals of the Malini so and so. In this regard, it is intimated that same estimate oblique proposal sent to our higher authority, higher headquarter, but observation raised by the higher headquarter that the rate of RS 280 per square meter is very high. This is the in pertains to the rate. As we have observed that the rate zones in the urban areas, so kindly issue urban area certificate. Hence, you are requested to provide the minimum rate per square meter and all above dimensions, the informations to this office. The matter could be sent to our higher headquarters timely. This is for your kind of, by this letter, what I'm pointing out is regarding dispute on the rate also. And the second letter, and let's keep this is internal correspondence made by the made to the Deputy Commissioner. The type copy is page number 187. Written by the Deputy Commissioner to the ITBP. 9th November 2018. I'll skip rest part. With reference to above cited subject, it is a price you that the land acquire for the ITBP at Parvat Forest, BP so and so has been awarded by number so and so. That is 6th September 2018 at the rate of 280 per square meter. So and so. It is informed your good office that it is a horticultural lane approachable by motorable road and it is not urban area. And no urban area certificate is necessary where the rate is same as per the government approved rate. Please note that serial number 9 of the gov approved rate. This is for your kind information, my lord. This is the correspondence, my lord, the notification correspondence made to the my lord, ITBP. And my lord, rest part is in Hindi, my lord, Hindi language, my lord. Type translated English copy is at page number 192. 192, my lord. Office
Yes.
memorandum. By office memorandum, the ITBP has issued that this is not as per the matter, the proposed as per the requirement as per the matter. The rest I'll skip page number 192. Now, may I take your lordships to page number 193, last paragraph, madam.
Yes. Yes.
Therefore, the proposal for land is written here with. Proposal was there, it is still we are on proposal. With request that the proposals may be sent as per the land authorized for each BOFs by the so and so Ministry of Home Affairs, the Government of India, or the land transferred at each BOP by the Assam Rifles, and if the Assam Rifles handed over the land in excess of 4 BOPs, their area is not also correct, as per the length then.
What is that letter? Page 193 letter.
My lord, this letter is in respect of my lord, but then my lord, may I take your lordships to the page?
Written by whom? Who? To whom?
This letter has been issued by the minister by office memorandum. My lord, we have issued letter. My lord, it is therefore, my lord, the request has been made to the district, my lord, authorities for modification of the letter, my lord. Since it is a government, my lord, the Ministry of Home Affairs, my lord, therefore, this by way of office memorandum, my lord, it is mentioned, my lord. Then in that case, my lord, may I take your lordships to again, my lord, page number 192, man. Area, MIP, BOPs, 9 PN, my lord, area handed over by the Assam Rifle, my lord. The actual land which has been taken over by the ITBP from the, my lord, Assam Rifle is serial number 1, my lord. 4.25 acres. But area authorized for BOP is, my lord, 4 acres. And area proposed unit is, my lord, so and so. And the estimated cost. Serial number 2, my lord, area taken from the Assam Rifle is 6, but the, my lord, authorized BOP is 4. So this is why, my lord, the ministry has issued office memorandum, my lord. The authorized, my lord, the authorized to, my lord, authorized for the BOPs is, my lord, prescribed at serial column number 4. And the Dambian BOP of 9 BFP 3.50, but authorized is, my lord, 4. It is within authorized, my lord. And my lord, the serial number 4 is 0.75 acres, but authorized is, my lord, 4 acres of land, my lord. So, my lord, this comes to, my lord, as per the estimated cost for, as per the assessment done by the district administration, it comes to 12 crore 93 lakhs 515, my lord. Therefore, please intimate when the land, the 4.5 acres at MIP, 6 acres at Malinie, and 3.5 acres at Dambian, and 7.75 acres was handed over in charge by Assam Rifles by why the battalion is acquiring excess land. Whereas the Ministry of Home Affairs and the Government of India has authorized only 4 acres of land for a BOP. Serial number 4, madam. At serial number 1, 2, 3, land for the dropping zone at MIP. Madam, this part is not required, madam. This is in pertaining to other place of liquor. 6, serial number 5. In the proposals of the all above the BOPs, the rate of land is mentioned at 280 per square meter, which is the rate prescribed for the residential plot at urban area of the horticultural land approachable by motorable road. Whereas the proposals should have been prepared for the land of above BOPs at the rate of the 120 manner. As per square meter is prescribed for horticulture fiat land manner. Therefore, the proposal for the land is written herewith. The ministry has issued this office memorandum. Therefore, the proposal for the land is written here with the request. Then the proposals may be sent as per the land authorized for each BOP 4 acres by the Ministry of Home Affairs, Government of India, or the land transfer at each BOP by the Assam Rifles. And if the Assam Rifle had handed over the land in excess of the 4 acres, then the proposals for the BOP may be sent accordingly. The proposals for the land at Malini and Italian and both the BOPs may also be sent to this office along with the above land proposal, so that the case may be forwarded to the post headquarters for obtaining the administrative approval and the financial sanctions of the financial sanctions for BOP's land. Madam. Why this has been issued is because there was the irregularity in publications of the notifications, in lack of the willingness certificate. In willingness certificate, the user agency has to specifically pointed out how much of land, how much of areas is required for the certain BOPs. But in excess of in the less than the area required by the Ministry of Home Affairs for each authorized BOPs. But all of a sudden, Deputy Commissioner made a correspondence to the Secretary Land Management for publication of the draft for publication of the notification, which has been impugned the writ petition, my lord. All of a sudden, he himself, my lord, without any consultations with the, my lord, the user agency, my lord. This is the, my lord, the serious mistakes and the lacunas, my lord, done by the district administration. Therefore, my lord, this problem has cropped up, my lord. And my lord, may I take your lordships to page number 194? It is written to the Deputy Commissioner on 9/10/2019, my lord. To the Deputy Commissioner so and so regarding revised lane proposals, my lord, revised was proposed. Lane proposals of the MIPI, Malinie, Dambian, Alinea, Italian, and Alinea of the 9BN ITPP, so and so. My lord, location is given, my lord. My lord, I'll skip the rest part. My lord, may kindly see page number 195 operative portion. You are also further requested to furnish the evidentiary value of the basis of the such above BOP's land is declared as the community land, my lord. Lordship, we have already seen by this in the writ petition, my lord, this honorable court has given a directions to the Deputy Commissioner to verify, to cause an inquiry whether this piece of land belongs to a government land or the community land or a private land, my lord. Now, as of now, my lord, the ITBP has made a correspondence to the Deputy Commissioner, at least to furnish the evidentiary value whether this piece of land belongs to a community land or a government land, man. That has not been done. My lord, the revised authorization, my lord, we have made a communication. Revised authorization of my lord, this is official, my lord, the office memorandum, my lord, the Ministry of Home Affairs.
Where is the award dated 6/9/2018?
It is in my lord, page number. Impune award is at page number, my lord, 175, my lord. It was published, my lord, passed on 6 September 2018, my lord, page 175. Whereas land acquisition award, whereas an extent of the land measuring so and so hectares in the village of the Alinea, Dambian, Mipi, Malinia in Dibang Valley district, Arunachal Pradesh, owned by the person specified in this idle given below has been declared by the government of Arunachal Pradesh by number so and so, by notified by phase number so and so of the Arunachal Pradesh gadget number so and so, to with for establishment of the border outpost of the ITBP process at this location localities in Dibang Valley district. They understands that after full inquiry into the case and on the consideration of the various circumstances connected with the acquisition, here are as here before they set out. These are the land manner. Altogether, manner through area of the land manner. This is also not correct as we have pointed out, manner. And the total amount of compensation payable is 12 crore 93 lakhs 119, manner. Sorry, 519. And everything has been included, man. The specification of land is at page number 176, man. And the next owner, land owner name is at page number 177.
Did you write any objection to the Deputy Commissioner in between 24 April 2018 and 6 September 2018? saying that you don't require the land.
Between
24th April 2018. What is that date? What is 24th April 2018 date? You are not aware of. That is the notification issued for acquiring the land.
correct, my lord.
Did you,
Yes.
did you object to?
My lord, as I have already pointed out, my lord, this communication has been,
If you have objected to, it's all right. If not, then also all right. We are just asking, did you object to the acquisition of land? And
my lord, acquisition of land, that, my lord, later, and the correspondence is not made, my lord, acquisition, my
Okay.
lord, for correction, my lord.
so that is why there was no objection. This award has been passed on 6th September 2018.
My lord, my lord, as I have pointed out, there was no correspondence made to the ITBP by the deputy commissioner as well as the, my lord, the secretary land management, my lord. Of their own, my lord, they have initiated the entire thing, my lord.
Okay, all right.
No correspondence was, my lord.
Yes. Yes, proceed. It was not published in the newspaper.
Yes.
It was not published in the newspaper.
My lord, my lord, as per our records, my lord, it is in the official gazette only. No, it has not been published, my lord. They are also not controverting.
All right, all right. Yes, proceed.
Yes, they are also not controverting that this has been published in the notification, my lord. Thereafter, my lord, my lord, this is the only technicalities admittedly, my lord, done by the, my lord, ITBP. My lord, without making any correspondence by way of the office memorandum, my lord, after all, this is organization, my lord, by way of organization, this maybe, my lord, this is directly contrary to the, my lord, the notification issued by the state government. But, my lord, by way of office memorandum, my lord, regarding area, my lord, this has been raised, my lord. Page number translated copy is page number, my lord, 203, my lord. Or the internal communication, my lord, everything, my lord, the status of the land, my lord. But for the first time, my lord, we have made communications to the deputy commissioner regarding, my lord, has already seen at page number 194. It is 9/10/2019. And thereafter, my lord, by way of office memorandum, my lord, it has been published regarding the area, my lord. And another, my lord, the publication is page number 203. Kindly refer to your my lord, office memorandum. It was published on the 15 January 2019. Refer to your letter number so and so amended proposals for the land for the so and so post of so and so 9 have been forwarded to this office for administrative approval and the financial sanction. In this regard, it is intimated that the clear guideline has been issued by this office letter number so and so that your unit has taken over the charge of the land for the forward post so and so so and so. The proposal for the acquisitions of the land forwarded as per the taking over the charge of the land by Assam Rifles. If Assam Rifles handed over the land less than 4 acres of any forward post, then proposal forwarded as per the authorization letter so and so of for BOPs by Ministry of the Home Affairs. Since 4 acres of land are authorized for the BOPs, whereas the integrated BOPs are constructed by CPWD at the above forward force. Those lands have been provided by your unit to CPWD for survey at forward force before construction is as follows, man. The area is given, man. By this area, man, is so authorized area is same, man. After notification, this has been. Therefore, it is redirected that the proposal, para 3. Redirected that the proposal forward to this office as per the handed over the land by Assam Rifle for the above forward force. If Assam Rifle has been given in the
What
last.
is this letter? What is this OM?
This
Is it relevant?
it is relevant, Malad, as because we are
See,
pointing out that
Auto,
area is
see,
exceeds
land, just a moment. Land acquiring authority has acquired the land, passed an award, and you are passing an OM on your own, saying, huh? Is it relevant?
Malad difficulty is.
Okay, you proceed.
Malad difficulty is.
Yeah.
Without there being proper verification, in which BOPs, how much of land is required is not as certain. This is therefore in some forward BOPs, forward force, the areas are exceeds.
See,
And in
see,
some
Mr.
post,
Mr.
areas are less than the area required by the ministry.
Learned DSGI. Award was passed on 6 September 2018. Award has been passed. Now, in 15 January 2019, you are passing an office memorandum on your own. How it will, how this OM is relevant to nullify the award?
From the record, it is not seen that even the.
We are just asking, we are not stopping you, you can proceed.
By this, even the impugn award, it is not seen that clearly that how same has been initiated, and no clear communication has been made to the ITBP. And thereafter, up to this stage, again, they move the writ petition before this honorable court is at page number,
Who moved the writ petition?
landowners.
Landowner.
Yes. Page number 213. Two writ petitions of similar nature, different writ petition and common order. Page number 213, annexure 16, Akuli Mipi, Atu Mipi, Lasho Mipi, Russia Melo,
Yes.
and in another writ petition. And in this writ petition, we have raised an objection. This is the subsequent writ petitions.
This writ petition is relevant for
By
adjudication of
writ
this
petition-
appeal.
Yes, madam.
Huh?
From this writ petition, we came to know that the such notification was initiated by the district, the registered respondent, and as well as the deputy commissioner, madam.
Yes.
Yes, madam. So therefore, may I take your lordships to the page number, the relevant parties. This was passed by his lordship. Justice
This writ
Medi.
petition was filed by whom?
landowners, madam.
They are a party here.
Yes.
They are
Yeah,
respondents.
yes.
All of them.
All of them.
All of them are respondent.
Admittedly, all of them. Yes.
Okay.
This is by these writ proceedings. First, we came to know regarding these proceedings of this acquisition process by this from this writ petition, my lord, only. Paragraph 10, my lord, page number 119. This is my submission, my lord.
Yes.
Mr. So and so, my lord, I'll skip my lord, I'll submit the objection raised before the my lord, in the writ petition proceeding by the my lord, the ministry, my lord, at the ITVP is my lord, this is exactly what I have made submission. I made submission before the learned my lord, and division single benchman.
This writ petition was for what?
For payment, my lord,
For payment of the
awarded the my lord,
awarded amount.
which we have impugned in the notification as well.
Okay.
Now, my lord, by in the writ petition, my lord, in connected writ petition, my lord, we impugn the impugn notification and my lord, the award also. Mr. So and so, learned so and so, on the other hand, submits that there are certain lacuna in preparing the award by referring to the affidavit in opposition stated so and so. And learned counsel for this counsel has submitted that the raid itself is disputed, for which the deputy commissioner has approached. He further submits that the ownership of the land was itself in doubt, and as to whether it was the community land or the government land, and therefore there is no necessity to pay the compensation amount unless the factual aspects are clarified. And my lord, the rest let's give. From this, my lord,
Here, I think award was in 4 parts. 4 parts. Because they are involved 4 plots of land.
my lord,
All the
common award.
landowners of all the 4 plots had come.
Yes.
Yes.
For my lord, different location and same my lord, award of the
How many writ petition? 4
two
writ
writ
petitions.
petitions. Two
2
writ
writ petitions.
page 2 writ petition, my lord. Writ petition number 281 and writ petition number 274, my lord, of 2019. my lord.
281 is for which plots of land?
My lord, it is in common order, my lord. Specifically, it is not mentioned, my lord. But it must be in the my lord, their writ petition.
And 274 is for which 2 plots of land?
I'm sorry, my lord, that is from the my lord, impugn order by name, my lord, it can be ascertained also, my lord. But in the specifically, it is not given, my lord. But the honor list, as we have seen in the impugn, my lord, the award order at page number 177, and Ngashi Mena is the writ petitioner
All right.
274.
Proceed, you proceed.
Yes, ma'am. Paragraph, madam, I'll start from the again paragraph 14, madam. The act in question lays down the provisions of the making award, the under section 23 of the madam, the act by the collector. The said provisions lays down the factors which have to be taken into consideration. The court has also noticed that the under section 37, such award is final in nature. Though in exceptional circumstances, writ petitions may be maintainable against such an award. The same has to be restricted only on the grounds of the fraud in making the award, and not as a routine manner. More so when there is provisions for reference under section 64 of the act. This is the another matter wherein the drilling has started, madam. Admittedly, to make a fair submission before the
What had started?
the threat and the procedure has been drilling, madam.
Procedure has been derailed.
Madam, there is a provisions, madam, in the statutes of the Act of 2013. Madam, there is no provision as such as contemplated under section 64 of the Act 2013, where the reference can be made by the user agency, madam. But this honorable court, madam, to make fair submission, madam, to the utmost honest and respect. But madam, there is no provision as such. But however, this has been made observed in this particular paragraph. That section 64, madam, if we see, peruse the section 64, section 64 can be exhausted only by the interested party, madam, but not by the user agency. But this honorable court has made an observation in this writ petition, madam. They are observing the honorable court observing that they know there is, if we are agreed by the award passed by the character, But the ultimate remedy is section 64, madam. To my humble understanding, madam, the respectful submission, section 64 is not for the user agency, madam.
Did you file an appeal to this judgment?
Yes,
Okay.
appeal was filed and that was subsequent.
Let us continue on that.
Yes. In the instant case, in view of the fact that no effort has been made to challenge the legality and the validity of the award, and no step has been taken making the the reference of the collector, reference by the collector, it would be within the it would not be within the ambit and the scope of the learned so and so for to point out the lacuna in the award. It is established principles of the law that when a statute recognizes a particular mode to do particular thing, and that things must be done in the prescribed manner only and not by any other modes. And this is the observation made by this on the court. And in view of the I'll skip paragraph 17. In view of the aforesaid facts and circumstances and the decisions made, this this honorable court is of the opinions that a case for the interference is made out by the petitioners by this court in exercise of the powers under Article 226 of the Constitution of India. Accordingly, the writ petitioner has allowed and directing the respondent authorities to immediately deposit the award amount in the office of the Deputy Commissioner and any Devang Valley district, and in any case, within an outer limit of 3 months from today. On such deposit, the Deputy Commissioner would take necessary steps to release the same to the petitioner in accordance with law and after proper verifications. Mr. So and so, I'll skip.
Yes.
Against this, feeling aggrieved by this order, the ITBP filed it appeal, page 222, madam.
Yes.
Annexure 71. Read appeal number, at principal seat, 195, 2022, madam. Union of India, Director, Inspector General, and DIG. And
Appeal was dismissed.
appeal was dismissed. Therefore, it is one of the serious issues raised by the writ petitioner and the respondent hearing. That may I read this order, how this has been withdrawn, madam? Page number 224.
Yes.
Heard Mr. So and so, so and so, so and so, learned counsel for the respondent number 1, 2, so and so, and BD so and so, so learned counsel. In this appeal, the appellant had challenged the order dated, we have seen already the in common order, order dated 7/11/2019, by which the learned single judge directed the respondent authorities to deposit the awarded amount in the office of the Deputy Commissioner and in the Devang Valley districts within a period of 3 months from today. On such deposits, the Deputy Commissioner is to take necessary steps to release the same to the petitioner in accordance with law and after proper identifications. The learned single judge did not find merit in his submission advanced by the authorities in seeking to find fault with the award as regards the legality and the validity. The learned single judge also made the observations that, however, no effort was made by the authorities to challenge the same before the appropriate appellate forum. It has been submitted that the appellants are proposing to approach the competent forum to challenge the legality and the validity of the award. And we express no opinion as it is for the appellants to challenge the award before the competent authority in accordance with law. Since the validity of the award has not been put to challenge, we find no reasons to interfere with the learned single judge direction as on so and so. With above observations, we close this appeal, madam. Without making any observations at that relevant point of time, it was observed. It was observed that, madam, the appellate forum, madam, it has to be appealed before the madam. This is exactly what, madam, I try, madam, my respectful submission is, and what my humble understandings of the provision is, madam. The preparing appeal before the appellate forum, madam, it is under section 64, madam. So therefore, madam, may I take your lordships to kindly, madam, peruse one just to clear.
No, thereafter what happened?
Thereafter, madam, again, madam, thereafter, admittedly, madam, we filed There is no provision HS under section 64.
To challenge the award by
Award.
the user,
User.
sorry, requiring agency.
Correct, my lord.
Okay, then
Then we filed, my lord, admittedly, LA appeal, my lord.
LA appeal,
LA appeal, my lord.
yes.
And it was dismissed, my lord, without, my lord.
LA appeal where?
My lord.
Where did you file? Before the district?
No, before this honorable court, my lord.
Okay.
Before this honorable court. In the beginning itself, my lord, as I have already pointed out.
Where is that? Order of this court dismissing your LA appeal?
LA appeal, my lord, I'm sorry. Thus, it is enclosed, but not separate enclosed, enclosure is given, my lord. Only, my lord, along with the, my lord, 266. I'm sorry, 266, yes,
260?
6, and extra 20, my lord, of my read appeal, my lord. To make fair submission, my lord. This is the experience which we have seen, my lord. It's full of experience, but not logic, my lord. The experience, my lord, which
Huh?
life of law is not a logic, my lord, is a, my lord, full of experience, my lord. From by this, my lord, to by exercising this LA appeal, my lord.
It was filed under section 74.
Correct, my lord.
Okay. Challenging the award.
Correct, my lord.
Award is of September, 6, 9 September. Okay.
Correct.
Then it was.
And my lord, we have seen
Then
section 64, section 164 cannot be exhausted by us. This provision is not for us. So therefore, my lord, the other remedy option available is section 74, my lord. Then 74 we moved. That was dismissed only on merit, my lord, without making any observation, my lord. My lord may kindly appreciate. By this order, my lord, this is passed by his lordship, Honorable Justice Hukon. Madam, relevant pays. Madam, if I maybe allowed to read entire thing, madam, it will be picture will be clear, madam.
Appeal has been appeal under section 74 has to be filed within 60 days. 60 days.
Yes, madam.
So it was not filed within 60 days, so it was dismissed, something
No,
like
madam.
that.
No, madam.
No.
It is not exactly the case of the
Okay.
madam. Madam, if I am allowed to read, madam, may I read again, madam? How this is important, madam, is because madam, from this, madam, the whole procedure is madam, was
74
inappropriate.
74 appeal lies against the order passed under section 69. Is that the
69, madam.
case?
That
Is
was
the
the
case?
observation, madam.
Okay. Then the
Admittedly, madam, that is the
award-
factual, madam, set of
award-
position, madam.
award was not passed under 69, that's why dismissed,
Madam.
something like that.
Yes, madam.
Okay.
It appears from the madam, last paragraph, page number 270, madam. Madam, before that, to section 674, madam, just middle of the madam line. Section 74 of the right to fair compensation, transparency in land acquisition, regulates Act 2013, read as under. Appeal to the High Court, requiring body or any persons aggrieved by the award passed by the authority under section 69 may file an appeal to the High Court, madam.
In your case, award was passed under which section? Twenty? 26, okay, all right. Huh?
Section 23, madam.
23?
Yes, madam.
23, okay, all right.
Section 23, madam. So meaning thereby, madam.
So it was dismissed.
Yes, madam. Madam, last part, it appears from a bare perusal of the aforesaid provisions that the appeal under section, said sections can be papers, when the award was passed under section 69 of the, Act 2013. Here, no such award has been passed, has been made under section 69 of the said Act of 2013. And Mr. Kato, learned counsel for the so and so has also considered to the same. Besides, this appeal has not been prepared within a period of 60 days as provided in the so and so. Well, that so in subsection 1 of the section 74 of the said Act. In view of the above, and also in view of the submission advanced by the learned the advocates of both sides, I find this appeal not maintainable in present form, and accordingly same is dismissed. What I wanted to make submission is, without entering into the merits of the case, but only on technical part, this has been dismissed. Technical part, procedural mistake, admittedly, And thereafter, after the existing entire provisions, we have tried objection, making in objections the first round of writ petition in 218 and 274, wherein we raised an objection, by which proceeding, we came to know for the first time that there was an order passed, award passed by the district collector, and there was a notification issued by the land management department. And from that writ proceedings, first round of writ proceedings, we came to know before this noble court from where.
No, that you have said.
Yes, ma'am.
After you lost your LA appeal,
Yes.
then what happened?
Then we filed the writ petition number 211, madam,
Yes.
challenging the challenging the notification as well as the impugn award, madam.
Very good.
Yes.
Then what happened?
Then
Challenging the notification,
as well as the award.
26/4/2018, as well as award dated 6/9/2018.
Correct.
Okay. Then what happened?
And that was dismissed, madam.
Okay.
And
That was
dismissal.
dismissed.
Yes, madam.
211.
By
At phase 2 to 6.
Yes, madam. 226, madam.
Then what happened?
In that while proceeding, again, may I take your lordships to how this is very relevant, is page number 229, madam.
229.
Yes, madam.
Yes.
229, madam. Married, madam.
Yes.
Though this court is of the prima facie opinions that the appropriate remedy for the requiring authority is to file an appeal under section again 74, my lord. Again, my lord, their observation, my lord. My lord, this somehow, my lord, we are also, my lord, the students of law, my lord, they're making the provisions confused. Again, this observation has come up, my lord. The file an appeal under the Section 74 of the Act 2000, the learned counsel for the petitioner has submitted that the limited initiations of the award, which is the notification, is itself the subject matters of challenge to a specific query of this court. Regarding the ground of the challenge to the notifications, the learned counsel for the petitioner has drawn the attention of this court to the pleadings made in paragraph 11 of the writ petitions as far which no consent willingness from the requiring authority was taken for proceedings for acquisitions of the land in question. The aforesaid statement, however, has been verified to be true to record. Be that as it may, the MSO and so learned additional so and so advocate is directed to obtain instructions on the aforesaid aspects of the matter. Let's keep this part. Under ITBP, next page 230, madam. Indicated the specific instructions to be taken on the issue of the consent willingness certificate in the acquisition process, madam. This instruction has been come in the form of affidavit by the state respondent. Page number, my lord, 130 is 31, my lord. 231, sorry.
231.
31 is the starts from 239. My lord, page relevant page and the paragraph is.
See, 231 is an affidavit.
Yes, madam.
You refer to the order of this court. What happened to this WPC
Yes, madam.
211?
My lord, instruction was given. My lord, direction was given to the government advocates to take instructions whether the willingness certificate was obtained or not. To that extent, my lord, they filed an affidavit, my lord. By way of affidavit, my lord, instruction has come up, my lord.
Okay.
page number. It starts from the page number 231 and the relevant page is 233, my lord. Relevant paragraph,
Yes,
paragraph
yes.
4. May I read, my lord?
Yes.
With regard to the statement made in paragraph number so and so, it is up to, my lord, 14 of the writ petition. The answering respondents humbly begs to state that after going to the previous records from 2006 to 2016 and the series of the communications between the Deputy Commissioner and the ITBP, admittedly, the DC asked the ITBP to deposit the land revenue at the rate of 10% per square meters, amounting to 171,955 for the area 17,195 square meters at MIP and RS so and so. I'll skip so and so. This is the rate fixed and Dampier so and so. Next page. As one-time land revenue in the year 2008. The ITBP got its sanctions from the Directorate General ITBP in the year 2016. It is pertinent to mention herein that the private respondents herein claiming to have interest in the land in the year 2017 by approaching this honorable court by number so and so repetition number as we have already seen, my lord, wherein direction was given to the Deputy Commissioner to cause inquiry, my lord. Wherein the dishonorable court taking cognizance have directed the DCs to determine the ownership of the land first. The land for which the award was prepared is more than the land required and handed over by the Assam Rifles, which was vehemently objected by the ITBP on the ground that for acquiring more than the land required, it is mandatory to obtain the willingness certificate from the requiring authority in absence of which the acquisition process was void ab initio, madam. This is the exactly instructions of the state respondents, madam. And the next paragraph, paragraph 4, sorry, paragraph same page, paragraph 5. I'll skip, madam. The humble deponent begs to state that last paragraph 5, madam, last portion. State that there was some errors in the state government now admitting themselves that no, there was error caused by the respondent authorities in the issuing of the notification as well as the other process,
Yes.
acquisition process. The DC, without obtaining the willingness certificate from the requiring body, has passed the award on his own, this is in the form of it has to be taken into more cautiously, how this has been given. The more so, there is difference in the area of the land handed over to the ITBP by the Assam Rifle and the land to be acquired as per the award, which signifies the acquisition process was not carried out properly. That the answering deponent humbly begs to submit that since there are errors in the land acquisition process and the respondent number 3 failed to comply with respondent number 3, Deputy Commissioner, failed to comply with the direction issued in the order dated so and so passed by this honorable court in writ petition number. This is bunch of writ petitions, as to determination of ownership of the land occupied by then Assam Rifles and now ITBP. This honorable court may be pleased to allow the respondents to initiate the land acquisition process afresh or take necessary changes after obtaining the willingness of the ITBP for the interest of justice. This is the precisely the instruction given by the respondent authorities, admitting that there no process was initiated as procedure and as required under the rules. That is more precisely the willingness certificate.
Then what happened?
Then after this has been dismissed by this honorable court.
Yes. Despite this affidavit, your writ petition was dismissed.
Dismissed,
Where is that order?
Impugn order, madam.
Not the impugn order. Is that the impugn order here?
Yes, ma'am. That is the subject of this.
Where is that?
Common order, madam. Annexure, last annexure, madam. Page number 318, annexure 21, madam.
318.
Madam. In fact, we filed 2 writ petitions.
211 and what else?
2119 and 190 as well, madam.
No.
Common order, madam.
You had filed
211
and
209, 190, 2022, madam. No, by common order, madam, same has been dismissed, madam.
page number 318.
It was, madam, dismissed on
Page
8
number
8, my lord, page number 326. Annexure 21, my lord.
326.
My lord. 8/9/2022, my lord, by Honorable Justice SK Meeting.
This is an order passed in WPC 190
Both, my lord, common order, my lord.
and also
111, my lord.
211. Okay, yes.
By common order, my lord, both the writ petition has been dismissed, my lord.
On what ground?
Basically, my lord, my understanding of the law is, my lord, basically on the delay basis, basically on the, my lord, the res judicata, my lord.
What res judicata?
My lord, res judicata is not applicable as me, because, my lord, to my respectful understandings, my lord,
Not your understanding. What the court has said first of all.
my lord, it is in page number 330, my lord.
330. Yeah.
Principle of law of res judicata ex sub judice will not, my lord, applicable in our case, more precisely, my lord.
What was your ground of challenge to the notification and the award?
My lord, no,
In the writ petition
in the writ
211?
petitions, my lord, no willingness certificate.
Okay, no.
And basically, my lord,
Willingness certificate is required under which provision?
and provision of the, my lord,
Section?
yes, my lord. Kindly see, my lord, page, right to fair compensation and transparency in, my lord, rules 2015, my lord.
Rule.
My lord, right to fair compensation and transparency in land acquisition, rehabilitation. and resettlement.
215.
No, my lord, it is rules 2015, my lord.
Which rule?
Right to fair compensation and transparency acquisition, transfer, land,
Of course,
In-
that rule, but which rule? 6, 7?
rule 3,
Yes, rule 3.
request for land acquisition. Rule
Yes.
3, man.
It is pursuant to that only land acquisition can
Yes, ma'am.
proceed. Yes. Okay.
Exactly.
Yes.
Paragraph, my lord, page 330, para 17, my lord.
Yes.
16, sorry. The issue of limitation has been argued along with the issue of the res judicata as well as the res sub judice as well as the res judicata, my lord. The issue which has been arises for the determination in the present interlocutory application is that of the maintainability of the writ petitions. There is no manner of dispute that the powers conferred by Article 226 of the Constitution of India to a High Court is plenary in nature. However, it is equally important is such plenary power are to be exercised judiciously and in extraordinary circumstances wherein the issue of the equity of the equal importance. This court, by exercising the aforesaid power, is of the equity wherein the conduct of the parties approaching this court becomes important and relevant. In the instant case, there is no manner of the doubt that the following the provisions of the Act of 2013, an award was passed on 6 September 2019 by the Deputy Commissioner, Dibang Valley District. They said award being passed and published in accordance with law, if any party was aggrieved by the same steps as per the law should have been taken, which was not done, and it is the land affected persons who thereafter have to file writ petitions in this court in the year 2019 to get the compensation as per the award passed. The writ petitions were decided by hearing both the parties whereby the awarded amount was directed to be released within a time-bound frame. The Union of India has filed a separate writ appeal as indicated above. However, both the appeals were dismissed by the Honorable Division Bench, against which no further appeal has been prepared. Further, though the land appeal was prepared being LA appeal number so and so, this court by the order dated 10/12/2021 had dismissed the same as the same was not maintainable. Even the said order of the dismissal dated 10 December 2021 has not been questioned in any appeal. After the aforesaid developments, the questions that arises is that whether a press ground of litigation which has been instituted by the Union of India, that too by filing 2 numbers of writ petitions in the same period is maintainable. The aforesaid conduct of the Union of India in filing 2 writ petitions two numbers of writ petitions in the year 2022 in the opinion of this court is barred by the principle of res judicata in as much as there is a conclusive determinations of the issue in the earlier round of litigations in two writ petitions instituted by the said Union of India, who had gone up to the level of the writ appeal before the Honorable Division Bench, and the order passed in the writ appeal have not been put to challenge in the Honorable Supreme Court. However, the second writ petitions being writ petition number so and so is clearly barred by the principle of res sub judice, as well as the same has been filed with the same period as WPC number 190/2022. Another issue which has arises for the determinations is the questions of the limitations, though in the writ proceedings, there is no strict applicability of the Limitation Act in Limitation Act 1963. What is required to be seen is the question of laches in approaching the writ court, which is a court of equity as indicated above. The Honorable Supreme Court in the case of the state of Madhya Pradesh versus the Bhai Lal Bhai and others, they reported in 1964 AR so and so has laid down then, though the writ petitions would not be bound by the limitations prescribed in the Limitation Act of 1963. The court is only entitled to examine whether there is a laches and the inordinate delay in approaching the court, and what is barred by the Limitation Act is also required to be barred by the laches insofar as exercise of the writ jurisdiction is concerned. And for ready reference, the relevant paragraphs of the aforesaid judgment is extracted here in below. The learned judges appears to have the face to notice that the delay in these writ petitions was more than the delay in the petitions made in the Bhailal so and so case, out of which the civil number so and so has arisen. Now, on behalf of the respondent petitioners in this appeal, so and so, Mr. Adli has argued that the delay in these cases even is not such as would justify refusals of the authors for refund. He argued that the assuming the remedy of the recoveries by the actions in a civil court stood barred on the day these applications were made at that there would be no reasons to refuse the relief under section 226 of the Constitution. Learned Counsel is right in his submissions that the provisions of the Limitation Act do not as such apply to the granting of relief under Article 226. It appears to us, however, that the maximum period fixed by the legislature is the time within which the relief by a suit in a civil court must be brought under section brought 134 and 2 so and so may ordinarily be taken to be a reasonable standards by which the delay in seeking the remedy under Article 226 can be measured. The court may consider the delay unreasonable even if it is less than the period of the limitation period for a civil actions for the remedy. But where the delay is more than that, this period, it will almost always be proper for the courts to hold that it is the unreasonable. The period of the limitation prescribed for the recovery of the money paid by the mistakes and under the Limitation Act is 3 years from the date when the mistake is known. If the mistake was known in this case or shortly after January 2017, 1956, the delay in making this application should be considered unreasonable. If, on the other hand, Mr. Endley seems to argue the mistakes was discovered much later, this would be controversial fact which cannot conveniently be decided in the writ proceedings. In either view of the matter, we are of the opinion the order for the refund made by the High Court in these 7 cases cannot be sustained. In view of the above aforesaid facts and circumstances, and in view of the principles of the law governing the field, this court has no hesitations to come to a conclusion that the writ petitions are not maintainable. Accordingly, the instant interlocutory applications stand allowed and the writ petitions are dismissed as not maintainable. This is the order passed by the Honorable Single Bench. But my respectful submission is,
Yes.
principle of law, matlab, the res judicata is something different, where the matlab, the determination has been made and matlab, and same parties, matlab, and the determination, matlab,
Yes.
section 11. matlab. Directly and substantially, the matter, matlab, the ingredients of the matlab, the res judicata is directly and substantially, matlab, it is in the issue, has to be determined, matlab, between the same parties. Matlab, issue has not yet been decided, matlab. And that was matlab, technicalities, matlab. Merit of the case was not been touched, matlab. And that is my humble submission. And another, matlab, I'll not go into depth in that aspect, matlab. The another aspect, matlab, regarding the delay in this, matlab. No delay has been caused, matlab. From the very beginning, we are matlab, contesting the case when the first round of writ petition was filed. Then the simple direction was given to the deputy commissioner to cause an inquiry, matlab. Nothing was done. And in one case, matlab, in writ petition number 74, if I remember correctly, matlab, in 74, correctly, case of the Gita Mehu, wherein inquiry was caused by the deputy commissioner, and it was established that such piece of land does not belong to the petitioners, and it belongs to the government of Arunachal Pradesh. That was the and that is under subject matter of the one writ petition that is pending. That might be well known by the counsel for the petitioner, namely Mr. Mao, and that is still subject to my understanding. And regarding another thing, another important thing is second round of writ petition, there was no delay. In second round of writ petition, more particularly writ petition number 281 and 281 and 274, we have also contested, and thereafter, this honorable court, the honorable single bench, allowed the writ petition, directing us to deposit the awarded amount within a period of
Which one?
writ petition, subsequent writ petition number 281 and 274 of the, we have also annexed, Lordship has already seen.
Just
Against that writ petition, we went to the honorable division bench,
just a minute.
Page number 213, sorry. Page number 213. Agreed by this, the common judgment and order, we move honorable
one?
division bench.
Okay, which one?
There is no single space and the single page number 213.
213.
We are not leaving the matter unattended. Time and again judicial process was initiated. Even there was no space and a gap in proceeding.
213.
That was the continuous proceedings before this honorable court, before the honorable division bench, as well as the again before this honorable court. So question of delay and losses doesn't arise because we are under the judicial recourse.
Okay, 281.
213,
213.
yes, common
Against this, you had
when moved the honorable division bench by way of writ appeal 195, has already seen.
That is at 224.
224,
What is there?
Dismissal, just closing of that appeal,
Huh?
Closing of that appeal,
What do you want to point out?
Point out what I wanted to point out is, in no way, we are leaving the matter unattended. So there was no delay. The continuous proceeding of the continuous judicial proceeding in the subject matter.
Yes.
First, writ petition was filed. That Lordship has already seen at 213, 281 of 2019, where we have contested. Against the judgment, we went to the division bench.
Just a minute. Once again, come to page 222. Writ appeal 195.
Yes, ma'am. Yes, ma'am.
Is not it?
Yes, ma'am. This is the
This 195 writ appeal is filed against which order?
order, my lord, 213 order, my lord.
Order dated
213 order, my lord. 200, page number 213 order, my lord, order is at, it was passed on 7/11/2019, my lord.
in which writ petition?
Both the common judgment, my lord, both the writ petition 281, sorry. $281.
Can you point out that from the record of this writ appeal 195 of 2022? Order of at page which starts from 222 and which ends at 225. That this writ appeal is directed against the order dated 7/11/2019, passed in WPC 281. And there's another.
I'm sorry, my lord, this is the order passed by the Honorable Division Bench by His Lordship, Justice, Chief Justice acting.
Whatever
Nowhere
it
it
is.
has been mentioned, my lord.
Whatever it is the record, isn't
My
it?
lord. My lord, nowhere mentioned, but this is the only writ appeal, my lord, we prepared before the Honorable Division Bench.
Course title, you only give the writ appeal number.
My lord,
You don't indicate that this writ appeal is directed against which
My lord.
order passed in the writ petition.
my lord, it is fair to make submission, this is the only order, my lord.
No, we are not saying that. Yeah. You have done anything with the record.
My lord,
Now from the order also, we don't find, Mr. Saikia, is not it?
true.
See,
Yes, my lord.
if you are not, if anybody who is not acquainted with the entire facts of the case, it will not be apparent.
My lord, from the course title,
Yes.
from the name of the parties, can be, my lord, inferred that, my lord.
No.
No.
Saikia is not.
No,
See,
because-
similar parties can have many writ petitions.
Yes, this is very peculiar, my lord. That's why, my lord, in the first writ petition which has been, my lord, dismissed, my lord, there, my lord, only the, my lord, writ petition, my lord, of, my lord, 174 has been challenged, my lord, from saying the party's name, my lord. And against the another writ petition, my lord, they file another writ appeal. There, my lord, both the parties of the both the writ petitions
See,
has been.
Why this court is pointing out is
My lord, I will clear that.
not for this case.
Yes, sir.
It can happen in any other case.
Yes, sir.
Either you see in the order which you will pass eventually by the
Correct.
court may refer to, there also wants to refer to the writ petition number, isn't it?
Yes.
But if it is not referred to, at least it should be apparent from the
Yes,
cause title that this writ appeal is filed against which order of the writ petition.
my lord.
This, I think, should contain there.
In the. my
In
lord,
that case, my lord,
order-
that may be called for, my
See,
lord.
no. We're not disputing that. This.
my lord, in the order, it has reflected the number of the writ petitions.
Yeah, let us see. Where it is, it refers to only the order dated.
Order dated and the writ petitions, my lord.
Where? Point out, that is what I am asking, Mr. Carter.
I'm sorry, my lord, I have been,
Second paragraph, my lord,
Second,
paragraph, my lord.
yes, in this appeal.
The writ appeal has been filed by Union of India challenging the judgment.
No. Page number?
lordship is on page number 224, my lord.
Yes, 224. Course title starts from 222.
That point is, my lord, missing, lordship, as lordship pointed out.
Page 224.
Yes, my lord.
Please
It
go.
is the second writ appeal, my lord, where, my lord, the writ petitions were not mentioned. In fact, my lord, in the first writ petition, my lord, or writ appeal, my lord, 196, my lord.
It is-
In writ appeal 196, my lord,
There were two appeals.
yes, very, interestingly, my lord. In the first writ appeal, that is, my lord, 196, it was mentioned, my lord, the
No.
order dated and the two
First-
name.
First read table will be 195.
My lord, but my lord, in the order sheet, it was given, my lord, 281. Yes, my lord,
Because
196, my lord. First-
195 was filed earlier, that's why it has been registered
Yes, my lord.
earlier, and 96 is the second one, yes.
In 96, my lord, it
Ah.
was reflected, my lord, in the order of the division bench, my lord.
Which they have not annexed.
They have an next.
Page number?
They have not, I think, they have not annexed the 196 order.
But 196 in second item, my lord. Item number 12, my
Oh,
lord.
I don't know, 12. No, there, if it is reflected, it is all right. But nevertheless, 195 is also an appeal.
Yes, ma'am.
There also, it should contain.
Yes.
This, that is, see, it has no relevance to the case.
Right.
But if you look at this order, you don't find this writ appeal is directly against which writ petition.
Yes.
Yes. Kato. Earlier, there used to be in the course title, writ appeal
Yes, yes, yes.
in civil rule, then WPC. But nowadays, that appears to have been changed. Yes, Kato.
Yes.
What else?
So therefore, my lord, I'm on delay analysis, my lord. And there is no occasion, my lord, the ITBP has not taken recourse of the judicial proceeding, my lord. In entire proceedings, madam, from the beginning, my lord, we are contesting the case basically on the ground that, my lord, the no willingness certificate, no requisition has been given to the respondent authorities for the acquisition of the land, my lord, of their own. My lord has already seen in the affidavit filed by the state respondent, wherein it has been specifically mentioned that the certain procedure was not done, my lord. It was void ab initio, my lord. It is their admitted fact, my lord, admitted position in the past round. Despite that, my lord, the honorable single bench, my lord, the past and or the order which has been impugned in the writ petition, my lord. And therefore, there is no delay analysis. Therefore, there is no, my lord, res judicata. Res judicata, principle of res judicata will be not applicable, my lord. Well, may I take your lordships to the again my pleaded case, specifically in my I'm sorry, my lord. Page number, my lord, of my writ appeal, body of writ appeal, page number 52, my lord. Lordship has gone. Page number 56, my lord. 50, sorry, 52, 52. I'm sorry.
52.
My lord. My lord, 52, before that, my lord, I'm sorry, my lord, if we start from page number, my lord, that will be, my lord, more clear regarding res judicata part, my lord, we have raised, my lord. Page number 48. Res judicata part, my lord.
Yes.
Para 8, my lord. That the honorable single judge has failed to decide the issue of the res judicata and pass the common judgment in order that on the maintainability on the ground of res judicata following submission. It is humbly submitted that the res judicata means a subject matter that has been adjudicated adjust, or in the other word, the issue that have been brought before the court of law for adjudication, my lord. And for adjudications, and the court has passed the final verdict. But the principle of res judicata applies when a litigant attempts to file a subsequent lawsuit on the subject matter as issued and obtaining the judgments in the previous case involving the similar matter or issues. The definition of res judicata is given in section 11 of the Code of Civil Procedure Code is reproduced below. No court shall try an issue or the issue in which the matter substance directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties and the parties between the parties under whom they or any of them claim litigating under the same title and in the court of competent to try such suit, or the suit in which such issue has been substantially raised and has been heard and finally decided by the court. Well, this is the explanation.
Explanation, madam, 3 and 4 is important.
Hmm?
Explanation 3 and 4 of the CPC is important, madam.
Then in that case, my lord, may I read my lord, explanation also, my lord. The expression perma shall denote as
Constructive res judicata.
constructive, my lord. Maybe they imply.
See, this will require examination. You can't say that the petitioner doesn't have a case. We are not saying that they have a case, but this case will require examination. Yes, yes.
And my lord, next page, my lord, the explanation part, I'll skip, my lord. Page 51, my lord. C. Definition supra, that has been further amplified by the Honorable Apex Court in Civil Appeal number so and so of 2014, titled Jamia Masjid versus KB Radrappa, since then by LRS and others. It was observed that in order to attain the principle of the res judicata, the following ingredients must be fulfilled. The matter must have been directly and substantially in issue in the perma. The matter should be heard and finally decided by the court in the forma. The forma must be between the same parties and between the parties under whom they or any of them claim things under the same title. The court in which the forma has instituted is competent to try the subsequent suit or in which the suit has been substantially raised. In further, in Said Muhammad Salih Labbi, dead by LRS versus Muhammad Hanifa, dead by the LRS so and so, Justice S. Murtaza Ali, speaking for the bench of 2 judges, observed that before a plea of res judicata can be given effects, the following conditions must be proved. That the litigating parties must be the same and subject matter of the same suit must be identical and the matter must be finally decided between the parties. And as decided by and the third form, the suit must be decided by the court of competent jurisdiction. It is submitted then all the connected previous litigations were either dismissed and disposed of on technical grounds or has been withdrawn with the liberty to approach the appropriate forum, and further none of these litigations were decided on merit and final decision was passed thereon. Therefore, the imperial common judgment and order was and next paragraph. Res judicata part, this is that much only. So therefore, my humble respectful submission before your lordship is, in none of the litigations, actually it has been determined how the only on the technical part, the writ petition, the writ appeal was dismissed and the LA appeal was dismissed. And delay and lessons part we have already made out. So therefore, this is only the my respectful submission before your lordship is in the entire acquisition process. Nowhere the procedure has been adopted as established under as lordship has already seen in this rule 3. Minimum condition precedent is rule 3. That has to be actually at least that has to be followed. The deputy commissioner as well as the secretary land management of their own as admitted in their affidavit issued the notification which is void of an issue. So therefore, at this instance, both the impugn order, impugn notification as well as the impugn award, it may be set aside, and if lordship given the directions to the respondent authorities to initiate a press acquisition process by following the old procedure established by law, we are ready to acquire the land, as we have already seen in the ministry, OIM, for certain piece of land, this authorization has to be given by the Mantralaya. If the Mantralaya give, then the acquisition process can be initiated. So this is the rules and the procedure established. At this stage, therefore, my respectful submission before your lordship is both the impugn notification as well as the impugn order may be interfere with, and the order passed by on single bench in both the writ petition may also be interfered with. Subject to submission made by the counsel for the other party, I'll rest my submission. I'm sorry, my lord, I'm skipping another, my lord, I'm not pointing out, my lord, regarding the contempt case, my lord. Admittedly, my lord, the order was passed, wherein, my lord, the deposition has to be made within a certain period. And, my lord, personal appearance was also given to this honorable, given to the, my lord, the Secretary, Ministry of Defense. And in that case, my lord, we moved honorable Supreme Court, wherein, my lord, Supreme Court has stayed the personal appearance and given a directions to the respondent authorities to deposit the amount, my lord. And this 12 crore something amount has been deposited with the Deputy Commissioner, and that, my lord, proceeding is closed. And of course, that is not pleaded in our case, my lord, but however, my lord, it is relevant to point out, but the crux of the case is not that, the dependency of the, my lord, the SLP prepared before the Honorable Supreme Court. And the Honorable Apex, in view of the order passed by the Honorable Apex Court, but we have already deposited with the, my lord, awarded amount with the Deputy Commissioner. It is now the money, the amount compensation amount is pending with the Deputy Commissioner till date.
Any other proceeding pending before the Supreme Court?
No, madam. Pertaining to this land, madam, there is no land, madam. There is no. Madam, in that view, madam, while this, madam, the disposing of the, madam, the SLP prepared by the Union of India, madam, in that order, madam, I'm sorry, madam, I have not the. Copy is not
Against the order passed in the contempt case.
in contempt case as well as the writ petition, madam. But in that order, madam, it is, madam, we have already seen that in that order, madam, nowhere the amount has to be released or amount has to be returned back to the, madam, the ITBP or the government. It is absent, madam. But only depositing part, as in view of the order that order passed by an honorable court, Supreme Court.
I think that will be subject to the order that
True,
may
ma'am.
be
Exactly.
subject to this objection.
Exactly. Therefore, the honorable Supreme Court might have not observed that part also. Obligement.
Yes, how you propose to go about?
We will not take much time, my lord.
No, just a moment. You will not take much time, that's good. But do you think this case can be disposed of in a day or two?
In the second half, it can be disposed of, my lord. Because basically, my lord, just for the short, my lord, brief. Basically, they are saying that, my lord, initially it was occupied by the Assam Rifles. Subsequently, it was transferred to the, my lord, the ITBP, my lord. And in, my lord, behind the, my lord, the land owners, my lord, there is a proposal going on, internal communications between the Deputy Commissioner and the ITBP, that land will be, my lord, allocated to them and a revenue will be paid to them, my lord. And when we came to know about this aspect, my lord, we filed writ petitions before this honorable court. The honorable court has directed the Deputy Commissioner to verify whether it's a community land or a private land, my lord. Subsequent, though no specific order has been passed, 6 plots of land were there, my lord. And out of that 6 plots of land, my lord, which were subject matter of that writ petition, my lord, 4 lands were, my lord, notified for acquisition, and 2 plots were, my lord, not notified, saying that, my lord, these 2 plots are Anini and Italian are, my lord, government land, my lord. So, my lord, whether question of now basically he is saying that, my lord, my lord, in terms of the rule 3 of the land, my lord, this act, my lord, there has to be a, my lord, requisition from the, my lord, the requiring body, my lord. And he has misquoted the rule 3 of the act, my lord. It is for the, my lord, for the purpose of, my lord, social impact assessment, my lord.
Other than that, requiring authority is not say regarding willingness of the land to be acquired.
My lord, maybe, my lord, but in this case, situated thus, my lord, the land is only under the occupation of the ITBP, my lord. Now, may I just read the section rule 3, my lord, just for a moment, my lord.
Yes. Okay, assuming that rule 3 is for the social impact.
After completion of all the procedures of the social impact, my lord.
All right. Other than that, is there no other provision which provides that the requiring authority must be willing to, must express the willingness to the authority that such area of land be acquired?
Yes,
There's no such provision.
it is silent in this rules, my lord.
No.
But procedure is that, my lord, whenever, my lord, a requiring body needs a land for them, my lord.
Yes,
If it is not under occupation, my lord, then definitely they will make a request to the
naturally,
state government.
there has to
Definitely,
be.
my lord.
Here is a case when the requiring authority says, we don't want land, we don't want land.
No, they never said this, my lord.
No. See, there is one contention there. Even if they don't say so, requiring authority must expressly say so.
Yes.
That we may be, for us, such area of land may be acquired. Now, unless that is there, how can the acquiring authority can proceed with the land, the acquisition of the land? That has to be there.
Yes, it is true, my lord.
Yes.
Here
Otherwise,
in
it will be very dangerous.
yes, my lord. Here in the
Now,
case,
authority will acquire a plot of land and give it to the High Court. You take
my
it.
lord, I understand, my lord.
We don't want to, though we
Yeah.
don't want that they'll give it, then we'll have to take it.
My lord, Acquisition Act is a
Yes.
court itself, my lord. Same, my lord. He says that when there is no requisition, my lord, the requisition provision the rule is for the only for the social impact assessments, my lord. Then, my lord, my lord has rightly observed one point of time that once the land acquisition notification has been issued, my lord, it's a gazette notified, my lord. The minimum requirement of the issuance of the notification is that, my lord, there has to be a notice to the landowner, my lord, and the persons for whom the land is to be acquired, my lord.
That is the second stage.
Yes.
Second
After-
stage.
Yes, after my
To
lord,
begin with, if you wish to issue that notification,
My lord.
where is the willingness certificate?
Suppose, my lord, if there is no willingness certificate,
Yes,
and the land acquisition notification has been issued,
yes.
after issuance of the land acquisition notification, if they are aggrieved by the notification, my lord, it's an statutory provisions, my lord. They can make an objection before the acquisition authority. Suppose the acquisition authority doesn't listen, my lord. Suppose, my lord, sorry, my lord, sorry.
Yes. So you see, in view of that, I don't know what my sister will say. At least I am of the view that they have a case to be examined, not that they have a case to be allowed. They definitely have a case to be examined, which will require some time. So keeping that in view, because if we hear, judgment will also have to come. You take a holistic view. So you want to continue tomorrow, or we will defer it to the 3 weeks, 4 weeks? But in view of the fact that this case requires examination. Otherwise, if we take a simplistic view, they may have in all probability, if they may succeed in appeal also. Prima facie of the view is, though it's not a final view, that the real issue appears to have not been determined in any of the proceedings. There were lapses on this side also.
No, my lord. To that I will briefly reply, my lord.
No, no, you want to continue the hearing? Huh? If we hear, we'll have to deliver the judgment and we are not going to keep it CAV. The judgment which we can't dictate in the open court, we will not take it up. You have to appreciate that fact. Hmm?
Well, then, next time we will given, my lord, in that event.
3 weeks, 4 weeks, okay?
That will be, my lord, much longer, my lord. At least 2 weeks, my lord.
Huh? 2 weeks.
My lord,
We'll consider, you have partly, you have succeeded to a great extent today.
I'm highly obliged.
Though this writ petition was directed to be listed after 3 weeks on the prayer of Mr. I. Bam Learned Counsel for the respondents by the order dated 11/9/2023. This writ petition came to be listed today for hearing on a mention made by Mr. I. Bam Learned Counsel for the respondent on 12/9/2023. To start, the Learned Counsel for the parties. Is spread for the Learned Counsel for the party listed after 2 weeks. 2 weeks. Okay, 2 weeks.
The main relief sought for has already been addressed, my lord.
Yeah.
So the clients have instructed me to withdraw the petition, my lord, with liberty to press, file a press, my lord. Could it be taken up today, my lord, unlisted? Or subject to lordships?
If the record comes before the court rises,
Yes,
we'll take it.
highly obliged.
I beg to mention item 4 to 11
Yes,
and 24. These are connected matters, madam.
yes.
Madam,
Four.
there are some more similarly connected matters, madam.
4 to 11 or 10?
11 also, including 11
11,
and 24.
24.
These matters, if my lord, fixed on 13th of October.
All right, on the prayer of Mr. N. Rata. We fix it on 13. On the prayer of Mr. N. Rata, the additional Auditor General, list these with petitions on 13th of October.
May I please, Lordship? Lordship, in this.
Yes, it will be 4 to 11 and 24. Yes.
Lordship, in the similar matter, Lordship. The one more matter, WPC 50 of 23, Lordship, which is the similarly situated matter, Lordship.
It is listed today.
No. It is, it's supposed to be listed with item number 4 to 11, Lordship. In the last occasion, I'm appearing on behalf of Mr. G. Tarak, Lordship. In the last occasion, the Mr. Standing Council has informed the court that the one matter, WPC.
What is your WPC number?
50 of 23, Lordship.
50.
Lordship.
Okay, along with 50 of WPC
Lordship.
50 of 23.
Lordship.
Okay.
Deeply applied.
My lord, I'm on behalf of R. Sonar for adjournment.
Item number
It's
1,
today, item number 25.
item 25.
Yes,
Yes, when do you want?
sorry.
When do you want?
After 4 weeks,
Okay, on the prayer made on behalf of our Sona, on the council for petition listed after 4 weeks.
like,
May I please, my lord?
Yes.
Here I am challenging, my lord, one impugn order, my lord. Notice you will find at page 65, my lord. Wherever, my lord, the place if I is the 65, my lord, may I read, my lord? By the Deputy Commissioner to the Deputy Registrar General, Office of Director Census of Nation, Arunachal Pradesh, Shillong minor. Regarding change in administrative boundaries in respect of the district Dibang Valley, in reference to letter dated September 6/7/2021, regarding freezing of boundaries of administrative units, the undersigned would like to submit that the finalized list of villages later to be merged back to its mother village as per required format. Accordingly, my lord, page 66, my lord. Serial number 1, my lord.
Yes.
Bianli village, my lord. And the manor Kamui village, serial number, my lord, column 3, my lord. This has been merged to, my lord,
Which village?
Biani village, page
Yeah.
66, my
Yes,
lord.
Bianli.
Biani village is the mother village, my lord, one village, my lord. And Kamui is the, my lord, the village, so-called village, my lord, has been merged with the Biani village, my lord. Column remark, my lord. Kamui village has been merged with its mother village, Bianli, my lord. Well, what happened in this case is that, my lord, the officials of the, my lord, census department, my lord, in connivance with the respondent number 8, my lord, they have, my lord, created, my lord, one census village, my lord. Lordship will find at
Who is respondent number 8?
respondent number 8 is the, my lord,
Private person.
private person, my lord.
Okay, he is a resident of Congo village.
My lord, my lord.
Resident of Congo village.
My lord, at page 38, my lord, kindly see, my lord,
Page
38, my lord,
38.
is the district census handbook of Dibang Valley district, my lord. My lord, at page 39, my lord,
Yes.
my lord, Kamui village, serial number 13, my lord, Kamui, my lord,
Yes.
my lord, location code has been given, my lord, saying the total population is 29, my lord, and household is, my lord, 4, my lord.
Total population is
29
yes.
and total household is 4, my lord.
Okay.
My lord, in fact, the land called Kamui is the, my lord, ancestral land of the village Mipido, my lord, of the petitioners, my lord.
Village Mipi.
Mipido, my lord.
Mitigo.
Mipido, my lord.
That name is not here.
Mipido, my lord.
9, serial number 9.
9, my lord.
Mipido.
Yes, my lord.
Yes.
Now, my lord, when we did not know, my lord, this is of the, my lord, 2011 census, my lord. We did not know, my lord, that a new village has been created, my lord, called Kamui, my lord. In fact, this land belongs to us, my lord. There is the agriculture and horticulture land, my
You
lord.
are of Mipido village.
Mipido village, my lord. Then when we came to know, my lord, we made a, my lord, complaint to the, my lord, Deputy Commissioner, Lordship will find at page 36, my lord.
Yes.
Prayer for settlement, my lord, to the, my lord. Prayer for settlement of the land dispute over Kamui, my lord, may and Brande, my lord, may Evan Brande, in between says GP Mihu versus
Land dispute. This is a land dispute.
land dispute, basically, my lord.
Kamui and Brande.
My lord, yes, madam.
Yes.
With the de-recognition of the Kamui village as new census village thereof, my lord. Because, my lord, this has been proceeded without knowledge of us, my lord. Then, my lord, the copy was forwarded to my lord director census also, my lord. Lordship will find. And in the meantime, my lord, one, my lord, on RTI, my lord, Lordship will find at page 47, my lord. The Statistic Department, my lord, of the Rohing has verified, my lord. A verification report has been given, page 47, my lord. Report on the spot verification of the village Kamui. In reference to letter number and subject cited above, it is to inform that as per on the spot verification done on 14/7/2021 to ascertain the existence of village Kamui in Mipi Circle, it has been confirmed that there only exist 2 hunters' hut with no population and 0 household, my lord. On our complaints, my lord. Thereafter, my lord, again at page 49, my lord, it was further clarified to the Public Information Commission by the, my lord, Assistant Director, Economic and Statistic, my lord. Resolution of complaint against creation of census blaze. In reference to the subject above, the undersigned has received several complaints regarding blaze, Kamui, Mipi Circle. Hence, in order to resolve the matter, the undersigned had issued an order for on-spot verification on 13/7/2020 in order to ascertain the existence of the blaze Kamui. During on-spot verification, the blaze, it was found that there exists 0 household and 0 population in the blaze. Hence, the undersigned would like to assure that action will be taken in this aforesaid matter before 31 December 2021, my lord. Then, my lord, one of the blazers of the, my lord, Mipido blaze has written to, my lord, because no action has been taken, my lord, in this regard. So, my lord, representation was made to the director census, my lord. So, you'll find at page 50, my lord, by the blazer of the, my lord. The type copy, lords, you will find at page 51, my lord. May I read, my lord? Non-adherence to the director, my lord. Non-adherence of my complaint letter regarding illegal creation of census blaze thereof. Respected sir, with due respect, sir, on 24/4/2020, my father Sri Sachin submitted complaint letter regarding illegal creation of census blaze, namely Kamui, under Mipi Circle in census 2011, copy enclosed, violating census rules for census by census enumerator or and the supervisor respectively. As per policy, if any citizen wants to create census blaze, they have to obtain NOC from the nearest blaze, Headgang, Bura, blaze under permission of the circle officer, district administrator. But in this case, they have failed to obtain any of the above NOC or permission. They have violated the census rules, misused their position, making false statement to Government of India, misled the government while giving census data, etc. At the time 2011, no any house exists there, and still date no any house or of any individual exists there. In this regard, I personally requested DC Anini and Circle Officer Mipi respectively, but they failed to take any action against them till date. On 10 September 2011 to 21, DC Anini issued order under section 145 stated that the status quo should be maintained regarding community land despite the dispute, but he fails to give any order against the census enumerator and the census supervisor, which also the same complaint submitted with that letter. Therefore, I request your good office to pass magistrate inquiry against the census enumerator and the census supervisor by the DC Anini, Circle Officer Mipi, District Statistical Officer Anini for the said and submit report to the audience. In response to this, my lord, the director of census has, my lord, written to the commissioner, my lord, economic and statistic, my lord, Government of Arunachal Pradesh, my lord, page 52, my lord. My lord, type copy is at page 54, my lord. To the Commissioner, Economic and Statistics, Government of Arunachal Pradesh, Itanagar. A resolution of complaint against creation of census blaze. I am directed to state that a complaint letter dated 26/9/2001 has received from Rakhini Mipi of Mipi Circle by this office on 1/10/2021 regarding creation of new blaze, is Kamui under Mipi Circle of Dibang Valley district. The blaze was created during census 2011 by Government of Arunachal Pradesh. Over the decade, no complaint has been received by this office. Moreover, the blaze has already been allotted MDDS code. I would like to mention that the blaze once created cannot be deleted. The applicant requested to this office to form magistrate inquiry against the census enumerator and census supervisor, census officer Mipi and district statistical officer Anini, Dibang Valley district. In this regard, I would like to inform that this department only acknowledged blazes which are recommended by the state government, district authority with notification or by a certification of the concerned deputy commissioner under this his seal and signature. Thereafter, this office forwards the same to Registrar General and Census Commissioner of India, New Delhi, for recognition of the blaze. This being the case, it is requested for you kindly intervene for early resolution of the issue, my lord. My lord, thereafter, my lord, we have obtained, my lord, RTI applications, my lord, many RTI applications, my lord. Instead of that, my lord, behind the back, my lord, the deputy commissioner had passed the impugn order, as lordship has already seen, page 65, my lord. The village was, my lord, the Kamui was, my lord, merged with the, my lord, mother village, my lord, behind the back of us, my lord.
Which village?
Kamui, my lord,
Ah,
was merged to the Biani village, my lord,
yes.
without our, my lord, behind the back of that, my lord. And ultimately, we had filed a RTI, my lord. Lordship will find one of the important documents, my lord. We file RTI, my lord, page 76, my lord.
Yes.
My lord, to narrate the information which are sought to be furnished, my lord. To furnish detailed copy of nearest GB of the village at the time who gave permission to create village Kamui. To furnish detailed copy of the village declaration notification of Kamui village. 3. Copy of recommendation order issued by Deputy Commissioner to Secretary District Administration for recognition to Kamui village. A copy of approval letter by Secretary District Administration for recognition of Kamui as a village. A copy of NOC from Divisional Forest Officer Dibang Valley, Anini. These are the information sought, my lord, and the reply lordship will find at page 77, my lord. At 78, my lord. Furnish detailed copy of nearest GB of village at the time who gave permission to create Kamui village, not available. To furnish copy of detailed village declaration notification of Kamui village, not available. It has to be declared by the government, my lord. Copy of recommendation order issued by Deputy Commissioner to Secretary District Administration for recognizing Kamui as a village, not available. Copy of approval letter by Secretary District Administration for recognizing Kamui as a village, not applicable, not available, my lord. Copy of NOC from Divisional Forest Officer Dibang Valley, Anini, not available. Other serial number 7, my lord. On the spot verification has been done on 14/7/2021. My lord has already seen those letters, my lord. 20/12/2021 reports found 0 population at Kamui village, and accordingly the letter submitted to Deputy Registrar General, Office of the Director General, Census Operation Arunachal Pradesh, Shillong, for merge back to its mother village, Bianli, copy and close, my lord. It was never part of the, my lord, Bianli village, my lord.
How you will show that it was part of Mipili village,
My lord,
Mipido village?
yes, my lord. My specific environment has been given, my lord.
No, any document?
My lord?
Any document?
No, my lord. My lord, for that, my lord, we have filed also, my lord. My lord, in their local language, my lord, there is a name for the Keva, my lord. That is also pending before the Deputy Commissioner, my lord. Huh? So with the in the back of the, my lord, petitioners, my lord, the village, my lord, in fact, this is not a village, my village was merged to, my lord, other village, my lord. So
What is Kamui then?
Kamui is our, my lord, land, my lord.
Your land.
Land of the Mipito village, my lord, for agriculture, horticulture, and hunting purposes, my lord. Now, respondent number 8, my lord, in my connivance with the enumerators, my lord, has done this all the things, my lord. In fact, my lord, he is one of the beneficiaries after creation of the village, my lord.
Yes.
My lord, will kindly see. Page 69, my lord.
$69.
My lord, we have filed RTI in all the departments, my lord. One of the RTI application to public health engineering, my lord, also will find at page 69, my lord. To furnish detailed copy of schemes where constructed a water tank in the year 2011 and name of the beneficiary list with household were connected, my lord. The answer, lordship, reply is, lordship, at page 70, my lord. The right side, my reply. The sanction was namely extension and improvement of water supply at Kamui during year 2014-15 and sanction amount of rupees 11.5 lakhs by sanction order number such and such such and such. The name of the beneficiary who benefited the state scheme is Chandra Miho. Respondent number
What
8.
is
my-
this letter at page 65? 6th of July 2021.
This is the, my lord, after the, my lord, the director census, my lord, Shillong has asked the, my lord, commissioner, state district of government of Arunachal Pradesh to make an inquiry about that, my lord. This is subsequently, my lord, instead of doing all this inquiry, my lord, the deputy commissioner has,
Where is that?
March-
Where is that letter?
my lord,
Where is that letter?
letter of director,
6th of July 2021.
6th of July, my lord,
In reference to the letter number ARZ.
here is Shillong, my lord. It was continuous of, my lord. Hmm? Page 52, my lord.
Page 52.
Yes, my lord.
No. 6th of July 2021.
That I did not have, my lord, because by that order on receiving our complaint, my lord, there was direction to freeze the boundaries, my lord.
What is this freezing of boundaries?
Because we have disputed that, my lord, that's why, my lord.
The dispute is between you and whom?
Our, my lord, the land, my lord, and the private respondent, my lord. And by
Who are-
his act, my lord,
Who are the private respondents? How many?
only, my lord, one, my lord, respondent number 8, my lord.
Only one.
Yes, my lord.
How many petitioners?
Petitioners, my lord, are,
9.
yes, my lord.
What is the dispute between petitioners and the respondent number 8?
My lord, we came to know about that, my lord, census report only when, my lord, the respondent number 8 constructed a hunting, my lord, hut, my lord.
Hunting hut.
Yes, my lord, in our land, my lord. Then we started inquiry, my lord. Then came to know that, my lord, there is a census, my lord, of 2011 whereby our, my lord, land has been declared as a census village, my lord. Then we started filing RTI applications, my lord, and made complaint to director of census also. And director of census asked the commissioner, my lord, of the state government to resolve the issue, my lord.
Yes, Ratan.
Notice may be issued for today, my lord.
We should notice.
My lord,
I appear for 1, 2, 3, 6, and 7.
Okay, I'll take up a petitioner.
responding number 4.
4 and 5.
4
4
and
and 5.
Ratan AAG for 1.
1, 2, 3, 6, and 7.
Okay. And M Tanga.
4 and 5.
Landed council for 4 and 5. Issue notice. Return over in 4 weeks. The steps for us. The steps by both ways to respondent number 8. Listed after 4 weeks.
Well, may I pray for an interim prayer, my lord, because, my lord, now for the land, my lord, we have already lodged a complaint before the village authority, my lord. And the village authority, my lord, at any point of time may decide the, my lord, issue, my lord, regarding ownership of that land, my lord. We have already filed a complaint before the village authority, and village authority has taken cognizance of the same, my lord. In the interim, may I pray that, my lord, the merger or impugn order may not be taken into consideration while deciding the ownership title, my lord. Because by this, my lord, a village has been declared, my lord, in favor of the respondent number 8, my lord. While deciding that, my lord, this should not be a, my lord, ground for, my lord, deciding the title of that land, my lord.
Yes, Ratan.
I don't know how this interim order will help in deciding the title of the land. Madam. Urging,
Because they will say that, my lord, it is already a notified place. It is in their favor, my lord. That may be,
that observation is, since there is a order for Kaba, that observation may be given. That merger while deciding this.
What?
The, if my lord says that there is a order for holding Kaba to settle the land dispute between the parties. Now, my learned elder brother is seeking an interim order for staying of that merger. The staying of the merger, whether it will have a bearing on the Kaba, which is going to decide the dispute. If there is an apprehension that if this is not stayed, and they may claim that since this Kamui village is already in their village, that observation can be made that Kaba, if any help, should not.
See, wherever you approach, it will all depend upon the admissibility of this evidence, which we can't preclude by order passed in the writ petition. Neither we can say anything about the admissibility or otherwise of the evidence. For that, whole lot of evidence act is there. It may not be a proper order.
then in that event, my lord, it is palpably illegal
And-
order,
and
my
su-
lord.
Suppose this is an admissible piece of evidence and very relevant, how can we by interim order exclude?
That was my suggestion, my lord. Then, my lord, in that event, my lord, it is prima facie that, my lord, there exists no household and no population, my lord, despite that it has been declared as a census village, my lord. Then that's why, my lord, that may be stayed, my lord.
Why not? I think the RTI replies already furnished
Where is the RTI reply?
that there is no household. That itself will be supporting to the petitioner if any Kaba is held.
My lord, page 60, page, my lord. First, my lord,
60.
page, my lord. Forty-seven, my lord.
87,
47, my lord.
47.
47, my lord. In reference to letter number such and such, it is to inform that as per spot verification done on such and such to ascertain the existence of Blaze Kamui in Mepi circle, it has been confirmed that there only exists two hunters hut with no population and
Yes.
household.
This is your evidence. That may be their evidence. It is free for the parties
I am, my
to
lord,
adduce whatever evidence you
I
have.
am taking back that, my lord, prayer, my lord.
Ah.
Now I pray that, my lord, because admittedly, my lord, there is zero population, zero household, my lord. They could not have, my lord, created a new village, my lord. And there is no notification for the creation of village, my lord. My lord has seen page 78, my lord. There is no approval by the government, my lord. Page 78, my lord.
Hmm.
The reply, my lord.
Yes.
Furnish detail of nearest GB village at the time of who gave permission to create new Kamui village not available.
Not available.
And my lord, furnish the copy of village declaration notification of Kamui village not available.
Yes.
Copy of recommendation order issued by Deputy Commissioner to Secretary DA not available. And the population was also given, my lord, no population, my lord. Prima facie, my lord, there was SS no village, my lord. It could not have been, my lord, recognized as a census village, my lord. So, my lord, This may be state, my lord,
Which one?
the impugn order, merger order, my lord. Page 66, 65, my lord.
If it is state, then what happens? Where will this Kamui go?
Come on, my lord. It is, in fact, it's not a
No,
village, my
No,
lord.
no, just now. First of all, you have to clarify what is this boundaries of administrative units.
Yes, my lord.
What is this boundaries of administrative units?
My lord, because earlier, my lord, it was our land, my lord. The villagers of Mepiti, my lord. Now it was, my lord, modified, my lord, and
According to, see, this is under Deputy Commissioner Dibang Valley.
my lord.
Whether Kamui remains with Bayanli,
Really, my lord.
it will still be administered by the Deputy Commissioner.
My lord.
Whether it is part of a MIPIDO,
my lord.
it will still be administered by the Deputy Commissioner. Is not it? Now the issue is, who will own this Kamui?
That is the, my lord.
That cannot be subject matter of
That will be
this
different,
writ
my lord.
petition.
Yes, yes, my lord.
Is not it?
I am challenging the
So,
process whereby, my lord, Kamui village has been created and ultimately it was again merged back to another place.
Then you have to tell this court what is the process of creation of a village.
I have stated that, my lord, there is as such no guidelines, my lord, specific guidelines. But, my lord,
Where is that?
but, my lord, I have annexed, my lord, some letters for other districts, my lord, whoever, some minimum requirements were there, my lord.
And how it will immediately affect you adversely?
Because, my lord, now, my lord, for instance, one instance has, my lord, seen, my lord, that the respondent number 8, my lord, who is from another village,
He is from where?
he is from, my lord, Bayanli, basically, my lord.
Bianli.
Yeah, my lord.
What happens if it is state?
My lord,
Then, my lord, what happens, my lord? Then in that village, my lord, now Kamui village, my lord, all the schemes, my lord, sponsored by government of Arunachal Pradesh or by the government of India, they will take the benefits, my lord.
Okay, this Bianli.
Yes, my lord.
Bianli people will.
Yes, my lord.
my lord, if my lord says page 65, the impugn, this,
65, yes.
yes, my lord, and annexure form A
Hmm? Hmm.
at page 66, my lord.
Hmm.
Here, my lord will say as many as 6 places, villages, so-called. They have been merged to their mother villages. My lord, of course, we have to take instruction why this merger, and otherwise, at present, I also cannot exactly say what is the reason.
Well, consider interim prayer on the returnable day.
Yes.
Because finding it what difficult, what kind of interim order?
Yes, ma'am. What adversely will affect the petitioner also immediately.
4 weeks.
Okay.
In the event the counter affidavits are not filed by the respondents on the returnable day, prayer for interim order may be considered by this court. Okay.
My lord.
Okay.
My lord. I'm challenging the appointment of the private respondent in the course of declaration. My lord, case is like that, my lord. I've been appointed as a declaration by
Will listen to hearing?
my lord. Yes, my lord.
Some urgency, the petitioner respondent is on the verge of retirement.
Respondent.
I think he's already retired.
No instruction.
Your appointment has been challenged.
Yes,
Your promotion has been challenged.
my promotion. has been challenged.
Any stay order?
No,
No stay order.
no, sir.
Then we hear it.
I have no issues,
Heard. Or do or the petitioner. GHA for 1. D Kamluk for 2 and 3. And TT Tara for 4. It is submitted to Relevant Council for the party that the pleadings have been exchanged. Tara, admit. Listen to hearing in due course.
My lord, this item, we are under instruction to withdraw it, my lord.
You have put a petitioner?
My lord.
Okay. Mr. T. Jamal on the council petition and Mr. White on the government. Mr. Jamal on the council for the petition on instruction 6 to withdraw the writ petition. There is a writ petition is still dismissed on withdraw. Interim order passed earlier, if any, is things vacated.
Obligations. Your lordship, this item number 12, my lord, we are waiting for this prior reply, my lord. For some time, maybe granted, my lord, 2 weeks, my lord.
Have you received instruction?
No, no, my lord. I haven't received instruction. yet.
Mr. A.K. Singh, council petitioner, and Mr. T. Jamo, standing education department, who pressed for and is granted further 3 weeks time for filing of a counter affidavit, listed after 3 weeks.
Yeah, please, my lord.
Yes.
The Arvind Council, Prakit Tama, has gone to answer the nature's call. The matter may be passed on for some time.
All right.
We need some time to file affidavit, your lordship.
I bound for the petitioner. R. Vasa, Islamic government advocate for the state, who pressed for and is granted for the 6 weeks time to file counter affidavit. Listed of 6 weeks. Yes.
My lord, this is regarding continuous extension of suspension period, my lord, without furnishing any charge sheet.
Yes.
On last occasion, my lord, at the motion stage, while issuing notice, my lord, they were, my lord, friends were directed to produce instructions whether charge sheet, memorandum of charges has been, my lord, issued or not.
Your Lordship, we have not received any instructions till that, Your Lordship.
Mr. Deepan, counsel for the petitioner. Mr. Y. Ram Lalit, government advocate. For press for and is granted further 3 weeks
My
time
lord,
to file counter
suspension,
affidavit.
they only have to take instruction, let it be after a week. My lord.
Listed after 3 weeks.
Or can it be after a week? My lord?
Huh?
This is a covert case, man.
Let them file an affidavit.
My lord, they have to only produce
What is
instructions, the
that?
charge sheet, memorandum of
that?
charges have been issued, my lord.
Ah.
And this is in continuation to this APCS fiasco case. We were involved. We were not even in the examination cell, my
How
lord.
many other cases are there? Such
Uh,
cases are there?
I have filed 4.
Where are they?
They have not been listed, my lord. They
We'll
have-
list it together.
Then let it be, my lord.
Huh?
Next week, my lord, I will give the numbers to the registry.
Okay, after, listed after a week.
Suraj Guru also was in terms of the same order as well.
Suraj Guru was different.
But no, the suspension was
Yes.
because of this issue.
Okay. After a week.
Yes. All right.
Please, your lordship.
Yes.
I have already taken step upon respondent number 6, but I want to file the affidavit, but I could not today. For series of copies.
16, Your Lordship, we have entered appearance. We have filed affidavit on behalf of respondent number 6, who is SI in this case. He has been implemented in person, so we are appearing on behalf of 6 also, Your Lordship. 3, 5, and 6 from prosecution side.
We have filed affidavit.
Yes, Your Lordship, the affidavit will rely on the affidavit filed by respondent number 3 and 5, Your Lordship. The respondent 6 will rely on the affidavit 3 and 5, which has already been filed, Your Lordship.
Then what is to be done?
Then admission hearing may be fixed, my lord.
When? Okay, on the prayer of
So after,
Mr.
after vacation, it will be better, my lord.
What is the matter about?
Murder is a custodial death, my lord.
Okay, on the prayer of Mr. U. Dekal, counsel for the petitioner, listed after 4 weeks.
Yes,
For admit, it is already for admission.
yes,
Okay.
yes.
Yes. Orders.
Oh, for
For orders, it was.
admission hearing.
Yes, Your
Yes.
Lordship. Deeply obliged.
May I please, your lords?
Yes.
Your lordship, by this writ petition, we are assailing the order dated 8/12/2017, passed by the learned Debt Recovery Appellate Tribunal. Thereby, my original application filed under section 19 before the Debt Recovery Tribunal Guwahati has been dismissed. And on the sole ground of mortgage as well as on the limitations.
Hmm.
So we are assailing, and this matter has been come up today for the orders line. But on 8/2/2023, the service has been completed. Thereby, the one learned advocate appearing for 2, 3, 3A and B has already filed their wakalatnama on records.
Okay. Yes. And Sora.
Yes, your
Then
lordship.
what is to be done?
Your lordship, this matter may come up for the hearing because this matter pertains to the financial of Central Bank of India and for the debts recovery issues.
According to you, all the respondents have been served.
Yes, your lordship.
You have how many respondents?
1, 2, 3A, 3B, and 4. Yes, your lordship. Total 4
See,
respondents are there.
The council who has filed Wakalatnama has filed for respondent 2, 3, 3A, B, and C.
C. Yes, your lordship.
He has not filed for 1 and 4.
Your lordship, 1 has already been completed, service has been completed. And 4 is this, I think, one learned senior advocate, I think he is appearing, Mr. Kato, I think that, as I have not wrong for pronunciation, your lordship. Only N Sora's Wakalatnama is pending as per my best information. That is on 8/2/2023. That has been submitted. Mr. N Kato, this Mr. Kato, I think I am not correctly pronounced your lordship.
Let's see, I think Kato and Sora are together.
Maybe. But private respondent is there. 1/4.
Oh,
Yes, your lordship.
okay. 4 is there.
And Debt Recovery Appellate Tribunal is a statutory body, your lordship. So
All
it's-
right, all right.
So matter is
Had,
matured.
had Mr.
M Sharma.
M. Sharma, learned counsel for the petitioner. None appears for the respondents. Though Mr. N. Sora. Second file है क्या? Second file में वकालत नामा है. वकालत नामा है. Yes, Tanga.
Some more time will be granted.
No, no. Which respondent?
It's for file number, respondent number 2, 3, 3A, 3B. This
C and 4.
Oh, not yet filed wakalat nama. Why have you not filed wakalat nama?
I have to take instruction from my agency. Otherwise,
See, office noting is N. Sora has not yet filed wakalat nama for respondent number 2, 3, 3A, 3B, and 3C. But he has filed wakalat nama along with Mr. M. Kato for respondent number 4.
Yes, sir.
See, you should come with the instruction. What's the use of? Case is listed, notified 2 days prior. You have to at least tell us whether you are appearing or not. If you say you are appearing, we'll record your presence.
Your lordship, if my humble prayer is that matter may be posted for the hearing, and in the meantime, they may be directed.
See,
to file.
we can proceed to hearing only if they say that they are representing the respondent.
Yes, your
But so far on record,
But service has been completed, your lordship.
they are representing only respondent number 4.
Yes.
All right. Then
Are you happy? Are you happy?
when did? Okay. Had Mr. M. Sharma,
Yes, your lordship.
learned counsel for the petitioner. Though Mr. Nyali Sora, learned counsel had submitted that he would be representing respondents 2, 3, 3A, 3B, 3C, and 4 in the order dated 8/2/2023. Office note dated office notes dated 9/3/2023, 29/7/2023, 28/8/2023 indicates that he is yet to file Wakalatnama on behalf of respondents number 2, 3, 3A, 3B, and 3C. Also, Mr. Sora, however, has filed a Wakalatnama on behalf of respondent number 4. So, since Mr. Sora Lamek Council had submitted that he would be representing respondents 2, 3, 3A, 3B, 3C as well in the proceeding held on 8/2/2023 as indicated in the order of discourse dated 8/2/2023. Let this writ petition be admitted for hearing. All right.
Highly obliged.
Let this writ petition be admitted for hearing and listed in due course.
Your lordship, if allowed, that date may be fixed because I have to,
When?
because I have to come down from Guwahati.
When?
This, your lordship, in the next month at any convenient date, your lordship.
Next month? You choose a date. You.
26th or 27th, your lordship.
27 October.
Yes, yes.
I hope it is not a holiday.
Okay. Your lordship then may come up on November 6th or 7th. your lordship.
All right. Admitted for hearing. In view of the above and as prayed for by Mr. Sarman and the council for the petitioner, listed on 6th of November.
Highly-
6th of November
highly-
for hearing.
My lord, I have already taken steps and I have already taken step by publishing the notice in a newspaper. Today, I have received copy of affidavit of respondent number 5. So I want to file rejoinder
How much time?
after 2 weeks, man.
Okay.
Very brief, Your Lordship. I'm appearing on a respondent number 5 here, and I've already filed with this.
He wants to file a reply to your counter affidavit.
Your,
He has filed affidavit, counter affidavit.
You want to file a reply?
I'll file rejoinder reply.
He wants to file a reply to your counter affidavit, for which he pressed for 2 weeks time.
yes,
Will grant 2 weeks time.
okay.
On the prayer of Mr. S. Koyang, Lamek Council for the petitioner, 2 weeks time is granted for filing of the reply to the counter affidavit filed by the respondent number 5. List it after 2 weeks. Okay.
Your Lordship, this, regarding this, item number 19. Item number 19, today I filed it only Wakalatnama. I may be allowed to file an affidavit in opposition in this, 4 time maybe.
4 weeks.
Yes,
Why not 2 weeks?
all right, 2 weeks maybe.
Okay. You file it within 2 weeks.
Yes, right,
No order is necessary. You can file it.
yes.
In case of item number 20, so just a second. 20, my lord.
Just a moment. This order which we have passed will be in item number 18.
18,
Okay. Are all these matters not connected?
connected.
Connected matters.
And any more order is to be passed?
My lord, in respect of item number 20, notice has been already published in a newspaper. But respondent number 5 is not appearing today. So in.
That will take care of on the next day.
Yes.
No other necessary.
Then let the matter be on the same date.
All will come. There will be a common order. Only you say that on the prayer of Mr. Esquire, now the counsel for the petitioner, 2 weeks time is granted for filing of a reply to the counter affidavit filed by the respondent number 5 in WPC 57 of 2020. Listed after 2 weeks.
All right.
And Mr. HR Oving, learned counsel for respondent number 5,
Yes,
in which you want to file affidavit.
in contempt case,
Huh?
item number 19.
Okay. In contempt case number 16
Yes,
of 2020. Respondent number 5
yes.
may file affidavit. May file affidavit within 2 weeks. Okay. Yeah, just a minute. In the meantime, Mr. H.R. Oving, learned counsel. In the meantime, as prayed for by Mr. H.R. Oving, learned counsel, representing respondent number 5 in contempt case number 16 of 2022. May file affidavit in the meantime, listed after 2 weeks.
All right.
Lordship, as per order dated 1/8/2023, I have already taken a step upon newly implemented respondent number 4.
Yes.
Lord, I am for respondent number 6. I have already filed affidavit.
You are for 6.
Yes.
Who else?
I am for
Just a moment. You are, your name? For the for 6.
I am for respondent number 1, Lord.
Kamduk for 1, LM.
Respondent number 5, D Lonel.
B. Lolen.
D Lonel.
D. Lona.
Yes.
For 5.
And your lordship, I'm for respondent number 2 and 3.
Uh,
We have filed our counter affidavit.
okay, P. Pangu for 2 and 3.
I am for respondent number 7. Respondent number 7.
7.
Yes, ma'am.
Your name?
The other one.
D. Ado.
The other. Yes.
Ado.
Yes.
D. Ado for respondent 7. Who is for 4? Okay. No, 4 is, he can't, it is a consume loy.
Yes, this is newly implemented respondent.
Okay, all right. Then, stop, para. Await service report of respondent number 4, as indicated in the office note dated 16/9/2023. We'll wait for listed after 3 weeks, along with service report of respondent number 4.
All right.
In the meantime, respondent, those who have not filed affidavit may directly file their affidavit.
Yes, anybody would like to file affidavit?
Yes, ma'am.
And who else? You are for response 7.
Yeah, yes, yes, ma'am. And I'm for the respondent number 5.
You will also file?
Yes.
One will not be filing.
Okay.
But
In
I will file my affidavit. In so the time may be granted.
How much time?
3 weeks, man.
Just then, like after hard, Mr. D. Kamduglan is standing counsel for land management department summit, representing respondent number 1 summits that the department, that respondent number 1 would not be filing a counter affidavit and would rely on the stand taken by respondent number 2 and 3.
Yes.
2 and 3 was stand taken in the counter affidavit filed by respondent number 2 and 3. Stop. Ms. P. Pangu, government advocate, representing respondents 2 and 3 submits that the counter affidavit by the respondents 2 and 3 have been filed. Miss, you have also filed affidavit?
No, I have already filed
Okay.
respondent number 6.
Mr. K. Appa, Learned Council for respondent number 6 also submits that the respondent number 6 has filed a counter affidavit. Stop. Mr.
D. Lona Lawsuit, not
D-
yet filed lawsuit.
D. Lona, Learned Council for the representative 5, and Mr. D. Ado, Learned Council for respondent number 7. However, press for how much time?
3 weeks lawsuit.
And are granted 3 weeks time to file counter affidavit. So list it after 3 weeks to enable filing of a counter affidavit by respondent number. They just list it after 3 weeks along with the service report of respondent number 4.
Much obliged, ma'am.
The Lordship,
Yes,
Lordship, as per the office note dated 4 September, the notice has been returned unserved. So the petition may be allowed to go for paper publication. Petitioners may be allowed to go for paper publication.
newspaper publication.
Yes, Lordship.
See, not found. What is the respondent number 4?
No, Lordship, there's only a sole respondent.
Oh, sorry. Akin Enterprises. What is this Akin Enterprises?
Lordship, it's a firm.
Who is the proprietor?
Lordship.
Who is respondent number 2? You have not described in your petition. Akin Enterprises. May no longer exist also.
Lordship, it does exist.
Huh? So you take instruction. Huh?
Lordship,
Who is this respondent number 2?
Lordship, there's no respondent.
Sorry, sole respondent. Who is this sole respondent? Akin Enterprises?
Lordship, it's a firm based in Naharlagun.
No. Who is the proprietor?
Lordship, I do not.
You do not know whether this kind of a firm exists or not. You take instruction.
Lordship, it does exist.
It does exist. How do you say so?
Lordship, we have tender documents, contract agreement.
And the documents, where it is?
Lordship, annexure number 2, page 15.
That is updated?
Lordship,
Page number?
page number 15, 15.
15.
The signature of the contractor is on page number 16, 16.
But who is this Akin Enterprises? See, Miss, your name?
P. Swargari.
Swargai.
Swargari.
See, there are a lot of companies established. They vanishes in due course of time. Not all companies exist. Likewise, is not it? There may be a lot of firms. This firm may have been there when tender process was initiated in 2016, is not it? In due course of time, this firm may have been dissolved. You find out. Otherwise, this postal department had gone to serve this Akin Enterprises notice in the address given by you. The postal department has come back, not to be found. So you still say that it exists.
Lordship, the petitioners have also informed me that in the prior occasion as well, they have deliberately not received the registered post.
That we don't know.
Also, Lordship, we have received a demand draft as well for part payment of the amount.
What kind of a firm is this? Registered firm?
Yes, Lordship.
Where have you described? You take instruction, bring it on record.
Lordship, date may be fixed.
When?
6 November. 6 November.
6 November, on the prayer of Miss P. Swargiari, Priyanka Swargiari. You are a CGC?
No, Lordship, SK Medhi.
Okay. Learned counsel for the petitioner. Listed on 6th of November. Mr.
May I please lordship?
You want to withdraw, no?
My lord, preliminary notice under section 11(1), my lord, issued earlier in connection with this writ petition, my lord, was supposed to be lapsed on 30th August. In that context, my lord, this writ petition was filed, my lord. After the notice was issued, my lord, the authority has come with a notification extending the period, my lord, another 1 year. So,
In fact, the time for this acquisition was about to lapse by 31st of August. Now, since the government has extended the time, another 12 months has been given for acquisition of the land of the petitioner. So actually in the writ petition there.
relief sought for is to a certain address, my lord. Almost address.
No, you want to pursue the writ petition or withdraw? That's what,
Just,
we are not
however, my
interested
lord,
on merit.
just one, my lord. One,
Moment you say withdraw, yes.
however,
Liberty?
liberty.
Okay, yes.
With liberty.
And also, I would like to pray that in fact this government notification extending the time may kindly be reflected in the order.
See, he is withdrawing, then why? See, he is now not contesting this case.
Yes,
He wants to withdraw.
on the ground that since we have extended another period of 1 year time for acquisition of their land. So in fact, in the writ petition, the issue raised was that since the time for acquisition of the land was lapsing by this month, so they
We will
wanted
not-
that.
we will not say anything. He wants to withdraw, we will permit him to withdraw.
Liberty maybe, that's all.
And Mr. S.R. Rava, learned counsel for the petitioners. Miss R. Vasa, learned government advocate for the respondent number 1, 1, 4, and 5. And Mr. D. Kamduk, learned standing counsel for the Environment Department, requesting respondent number 2 and 3. Mr. Raval, learned counsel for the petitioner on instruction, seeks to withdraw this writ petition with the liberty to file a request if so advised. Where is allowed, writ petition is dismissed with a liberty as per for.
Highly obliged.
My lord, last time I was instructed to this directed by this honorable court to bring the service record, my lord.
Service record?
My lord, contention here was that the private respondent.
Who's for the petitioner?
Mr. Thama was there.
Okay, Tama.
My lord.
What is this matter about?
It is, my lord, regarding my lord appointment, my lord, appointment,
Not appointment, transfer.
appointment in the post of my lord, this, my lord is page 50, my lord,
51.
my lord.
Yes.
This gentleman.
Tapan Konya is the
Tapan
petitioner.
Konya. Yes, he is a JT by, my lord, by designation, and he is holding academic health and hygiene, my lord. Academic health and hygiene. Two intervention he was holding. And apart from that, he was holding, my lord, residential coordinator residential school, my lord. And on this a promotion of this one academic this coordinator, my lord, he was looking after it, my lord. So this gentleman, one private respondent, Tapar Garam, has been put in his position, my lord, coordinator residential school, and
Okay.
health and hygiene. In academic and in health and hygiene, this petitioner has been engaged, my lord. Now, question here is, petitioner says that private respondent is not having B.Ed, my lord. That was the contention. B.Ed, my lord. So your lordship directed me to bring the service record, my lord. The service record is with us, my lord.
He has a bid.
My lord, yes, B.Ed, but we have to be very clear, my lord. There was B.Ed, but the time, though he was having B.Ed, at the time when this appointment was made, of course, it was not entered.
Transfer.
Yes, no, it was not entered. It was not reflected in the service book, my lord. That we have to make clear, my lord. But of course, DDSE has clearly.
So when his B degree was entered in his service book?
On, my lord, Four 8/2023, my lord. But he 4/8/2023, my lord.
On that day, his B degree was entered in his service book.
My
Then when was the impute transfer order made?
4/7.
4/7.
my lord.
So
The question here is, my lord,
Ah,
this gentleman was already there having B.Ed.
but which is not there in the service book, you can't
My
take it
lord,
into
my
account.
lord, my lord.
Yes, Garam.
In 2017, my lord.
Though it was not entered into the.
We'll set it aside, giving liberty to the respondent authorities to take a fresh decision.
Lordship, before that, Lordship.
See,
May I just make a submission, small submission, Lordship?
Hmm.
The legal issue is here, Lordship, is that, Lordship? Whether the petitioner, Lordship, he has a locus to challenge the qualification of the private respondent or not, whether because that is just the.
No,
Lordship.
not the locus. What is the guideline for transfer of?
Yes.
What is this coordinator, is not it?
Yes.
He is not challenging your transfer order, sorry, your degree, etc.
Page
Lord, sir.
24, man.
Page 24.
Page 24.
Page 24.
Para 12.
Yes.
Page 24, para 12, Lordship.
12.
This is the guideline.
Since he was working as a coordinator,
Lordship.
then he made inquiries how the coordinator is to be, how the coordinators are posted.
Lordship.
Then he found that when you were posted in his place,
Lordship.
he found that no, you did not possess B degree. That is one of the ground he raised.
Lordship. Lordship, may kindly take my affidavit in opposition, which I have been filed before this honorable court, Lordship.
Yes.
Though, Lordship, to be very fair, Lordship, Though my B.Ed record, though I have completed my B.Ed in the year 2017, Lordship, but I was, prior to that, I was appointed as an AD teacher. PRT teacher, I'm no doubt I'm a PRT teacher, Lordship. But having experience of 10 years, Lordship. Though I have completed my B.Ed degree in the year 2017, Lordship, it has been submitted before the authority, the director, Lordship, not the director, which office is situated in Itanagar, Lordship. Lordship will find at page number 21, Lordship.
Respondent number 4.
Lordship, affidavit in opposition, Lordship.
Yes.
Lordship. Page number 21, a type copy, your Lordship will find 21A, Lordship. The next page, Lordship.
Yes.
Lordship. The serial number, your Lordship will find 580, Lordship.
Yes.
This Tapur Soram, Lordship, now he is a Garam, Lordship, after executed affidavit, Lordship. MA IGNOU B.Ed from RGO, Lordship. This has been submitted before the competent authority, Lordship. That is this has been submitted before the Director of Elementary Education, Lordship, Itanagar, Lordship. Inadvertently, Lordship, it has not been recorded in the service book, Lordship, though it has to be recorded by the department, Lordship. It's no doubt that, Lordship, there was some fault from the department, Lordship. But now the Lordship, the question is, Lordship, whether I'm having a B.Ed degree or not, Lordship. It is clear from the record that even the petitioner has admitted that I have a B.Ed degree, Lordship. Though it has not been recorded in the service book, Lordship.
See,
Now,
you may have the best of the evidence in your hand.
Lordship,
If you not produce it before the court,
Lordship,
so court cannot take cognizance of those facts. Likewise, when this authority was transferring you there,
Lordship,
your B.Ed degree was not before him,
Lordship,
not before the authority. Though you had the degree since 2017,
Lordship,
and your certificate was lying at home.
Lordship.
He could not have access to what is there at your home.
No, Lordship, not in my home, Lordship. I have submitted before the director, Lordship. There is the office is at Itanagar, which is supposed to be forwarded to the DDC, Lordship. Now, Lordship will see.
Supposed to be forwarded to them?
No, Lordship, it's supposed to be the documents which I have submitted before the head office, Lordship, at Itanagar, Lordship. Though, as per the guidelines, Lordship, it has supposed to be record.
Then there is the TDSU.
TDSU office as well, Lordship. From the department side, Lordship. Now I'm admitting that there is some fault from the department, Lordship. Now the question is, Lordship, apart from that, Lordship. Now the question is, Lordship, how the petitioner has been appointed, Lordship. Lordship will kindly see the appointment order of the petitioner, Lordship.
No, did you challenge the appointment order?
No, Lordship. I'm just trying to project the case, Lordship, before your Lordship is there, Lordship. The appointment of the petitioner, Lordship, it was completely a temporary in nature, Lordship. His substantive post as a JT, Lordship.
What is your substantive post? PRT?
Lordship.
Both of you are a PRT and both of you are not a coordinator.
Exactly, Lordship. But since I'm qualified to hold the post of coordinator, Lordship. That's why the DDC, Lordship, has appointed me, Lordship. Now, Lordship, it is a well settled that, Lordship. I will not trouble your Lordship with the judgments or all, Lordship, but it's a well settled that, Lordship. When there is a decision taken by any authority, Lordship, which is legally, Lordship, is valid, Lordship, the court should not be interfering in that kind of matter, Lordship.
How it is, how the authority could have taken this decision in the absence of your B.Ed degree on record?
Lordship, it has been submitted before the.
He had only personal knowledge.
No, Lordship.
You had ring him up.
Lordship,
my B.Ed degree is lying at my home.
Lordship may kindly come to the page number 50 of the annexure, Lordship, which has been annexed by the petitioner, Lordship. That is the engagement order on. Now he has not been transferred from the upper civil district to other district, Lordship. Only the responsibility has been changed, Lordship. Now he is under the DDC. I am also under the DDC, Lordship. He will look after the hygiene and other part, Lordship. I will look after the coordinator, Lordship. That is the only issue, Lordship. What I'm proposing is that, Lordship, instead of, Lordship, interfering in the order which is not illegal and there is no mala fide, Lordship. Now the Lordship, there is a judgment of
our own High Court, Lordship. It says there, Lordship, when the malafide is alleged in the petition, Lordship, it has to be come with the cogent materials of documents, Lordship. Not even a single document has been raised by the
See,
petitioner.
there is no case, the case is not built on malafide, not built on violation of a transparent posting guideline, nor it is built on a violation of any statutory provision. His case is you are simply not eligible as per the guideline
Lordship,
for posting of a coordinator.
Lordship,
So ineligible person cannot replace him.
Lordship.
That is his case.
No, Lordship, there is a malafide has been alleged in the, in fact, in the.
Malafide rejected. We reject the allegation of malafide.
Then if there is no malafide, Lordship, then there is no remedy left for the petitioner to come before this honorable court, Lordship.
How can you, okay, you just tell this court, how can you hold the post of whatever it is, coordinator?
Lordship.
What are the essential qualifications to be possessed by the person who is going to hold the post of coordinator?
Lordship, it's a BEd degree, Lordship.
BEd degree.
Lordship.
On 4th of July, your BEd degree was on record.
It was recorded with the head office, Lord.
Decision
Not in
is,
the-
see, decision is vitiated. Who has issued this transfer order?
DDC, Lordship.
Come to page,
Lordship.
take the page. Page 51.
Lordship.
Was your BEd certificate before this DDSC
No.
on 4th of July?
Lordship, see, Lordship. Lordship, may, Lordship.
No, despite that, if you don't want this court to interfere, we'll adjourn it. If we don't interfere in this kind of a matter, then what for we are here?
What I'm suggesting is that, Lordship.
Monday, you do it on Monday.
My lord, kindly this may be disposed of today.
I can
Because
dispute.
pending since my lord.
Mr. Garam is vehemently arguing.
July.
And,
So, at least my brother also he has to understand
And the
that when
department has brought the record
Lordship.
where it has been disclosed that on 4th of July, the BE degree was not on record.
that is correct.
Subsequently, it has been entered.
And my
Despite
lord,
that,
my
you are
brother's
arguing-
submission, my lord,
Yes.
that they have submitted that BA degree to the directorate office, my lord. That is not the procedure also. That may be kindly confirmed from my learned friend, Standing Council
Oh.
Education.
4th of August, is not it, Mr. Jama? 4th of August, his degree has been entered in the service book.
My lord, my lord. In fact, it is also a fact, my lord. It was produced much before that, my lord. Much before that.
Where?
It was produced much before that here, and it is reflected in the page number 29 also, my lord, in 2018, my lord. Page 29, my lord. Page 29 of the additional affidavit, my lord. Or affidavit in reply, filed by the petitioner, my lord. Affidavit in reply, petitioner, filed by the petitioner, my lord. Page number 29, my lord.
So we pass order or not?
Kindly
My lord,
may be disposed of.
in middle, between, my lord, because it is fact, my lord, that this
Yes.
gentleman has passed on my permission, my lord. On my permission, he did BEd, my lord, in year 2017, but
He has suffered because of the procedural mistakes
my
you
lord,
have committed.
my lord, my lord, my lord,
So he can, you may sue them.
my lord. Please come to page number 29, my lord, or the additional affidavit filed by the this petitioner, my lord. It seems to have been submitted in the DDSC office, Daporizo, my lord. But still, that DDSC Daporizo didn't recorded it in his service book, my lord. Page number 29, my lord. May I read? To the Director of Elementary Education, Government of Arunachal Pradesh, Itanagar, submission, the copies of BEd certificate and DPE certificate, my lord. I am submitting here with the copies of the following teachers in respect.
No, see, whatever it is,
My lord,
but all particulars of an employee
my lord,
has to be gathered from the service book only.
My lord, my lord, my lord,
Really?
there is no dispute on that, my lord.
So,
DDSE failed to enter it, my lord.
Also, this application which has just my learned senior lordship has placed it lordship. It was on the record with the DDC only. Lordship. Now the lordship, the question is, to my humble lordship, the understanding so far as this matter is concerned, lordship. Instead of interfering in the order passed by the DDC lordship, let the direction is given to the respondent authority to take a decision whether to examine whether the private respondent is eligible to hold that post or not. If I'm not eligible, lordship, I
no,
may.
no, that, see,
That will be definitely consequently.
just now. Subject matter of adjudication in this writ petition is
Lordship.
the legality of the action done by the authorities on 4th of July. No, not subsequent to that. Nor prior to that. You have to appreciate that.
Lordship.
Is not it?
Lordship.
If the material was there on 4th of July before the authority,
Lordship.
then transfer is justified.
This document lordship reveals that the record is with the DDC lordship. Only it has not been put on record lordship, on the service book lordship. It's a very lordship. The situation here is lordship, whether I'm having a BA degree or not, lordship. Right from the inception of this petition lordship, the petitioner is claiming that I do not possess the BA degree lordship.
Legal adjudication is as such. Full stop and comma makes the difference. If you want this court to act like a Kevan,
No, lordship.
then, huh?
Lordship, yes, sir. Lordship, we are strictly on the law.
No.
They may still transfer him after this order is passed, after this 4th July order is set aside.
Lordship, in that way,
If
lordship.
they really need your service, is not it? That we are not precluding. That Jammu will decide. But on the face of the record produced by Jammu,
Lordship.
only one conclusion is possible. That on 4th of July, you could not have been posted there. Now you may be.
Lordship.
This you have to appreciate.
Now, lordship, apart from the records and apart from the legal submission, lordship. Now the DDC lordship. DDC lordship, the incumbent who has issued this order lordship in against the petitioner lordship. Now, since the allegation before this honorable court, now the DDC has changed lordship.
Mr. Ketama, counsel for the petitioner. T. Jammu, standing counsel for the Education Department representing respondents 1, 2, and 3. And Mr. P. Garam, counsel for respondent number 4. None has appeared for respondent number 5.
That's the completed.
Though, okay, despite service of notice. This writ petition is directed against the order dated 4th July 2023, passed by the Deputy Director of School Education, Upper Subansiri District, Dapur Region, comma, the respondent 3, no? Respondent number 3. Byte number so at page 51, whereby the petitioner, who is a junior teacher, the petitioner, who is a junior teacher, has been relieved from hygiene,
Health and hygiene.
health and hygiene. Academic comma, na?
Yes.
N, there is.
No, no, the academic comma, health and hygiene.
Yes, academic.
Intervention.
And in his place, the respondent number 4, who is a primary teacher, no? PRT means
Correct, ma'am.
primary
Primary
teacher, PRT within bracket, has been directed to assume no, just has been posted as has been assigned the duty of residential school coordinator in place of the petitioner. Stop, para. Though various contentions have been raised by the petitioner in assailing the impugn order dated 4th July 2023. The primary contention of the petitioner against the respondent number 4 with regard to the impugn order dated 4th July 2023 is that in terms of the 9th Executive Committee meeting of SSA Raja Mission Society, Arunachal Pradesh, I think it should be Rajya Mission, no?
Rajya Mission.
Rajya Mission Society Arunachal Pradesh held on 22nd November 2011 at C/S, S, apostrophe, comma, Conference Hall, Itanagar at page 22. One of the requirements for assigning the duty of residential school coordinator in terms of close trail thereof is that such an incumbent must have comma, inter alia, comma, the degree, so the Bachelor of Education, be it. There is one DL
Diploma in elementary education.
or Diploma in Elementary Education, DEL dot DEL. Stop. Para. The petitioner contends that though the petitioner does possess the BE degree, the respondent number 4 does not have either the BE degree or diploma in elementary education.
So it clearly says that I do not possess the BEd degree, Lordship, not either, Lordship.
Huh?
I am not qualified to hold the post, Lordship. So I do not have that submission may be recorded in that way, Lordship. Because in the petition, it has been contended that since I do not have a BEd degree, so
BEd,
BEd degree, Lordship.
Okay, not this DLD. DLED.
Lordship, Lordship, instead of use the word either, Lordship, I do not possess the BEd degree, Lordship. That is
Okay.
what the contention of the petitioner, Lordship.
Not this diploma.
No, Lordship. I do not have the required qualification to hold that post, Lordship, including the BEd and
Okay.
DLED.
Do you have this diploma in elementary education degree?
Yes, Lordship.
Sorry, diploma. You have diploma in
No, only B.Ed, Lordship.
Okay.
I
If you have diploma also, you will be eligible. Okay, you want this diploma to be not recorded.
No, Lordship. Instead of word use, Lordship, since the Lordship is using the word of either Lordship, either I do not possess the B.Ed degree with diploma and all Lordship. The contention of the petitioner is that I
It's
do
only
not have
the B.Ed.
I do not have the B.Ed degree.
Okay,
Lordship.
then you don't write this either. Are you clear? Huh? Don't write everything, huh? What?
But then in the previous sentence, the requirement in clause 12, that is correct. B.Ed stroke diploma in elementary education. But
Okay.
my contention will be
Just,
B.Ed.
okay, just then you write like this. You continue. One of the requirement, as per the so is that the incumbent inter alia should possess B.Ed stroke DEL.ED. First off. The specific challenge made to the review order dated 4th July 2023 issued by the DDSC Upper Sumatra District 0 by the petitioner is that the respondent number 4 does not possess the degree of Bachelor of Education.
B.Ed.
Bachelor of Education as per clause 12 of the 9th Executive Committee meeting of SSA Rajya Sabha Mission Society held on 22nd November 2011 at CS Conference Hall, Itanagar, page 22, Annex 2, and therefore the petitioner, and therefore the respondent number 4 could not have been assigned the duty of residential school coordinator by the Impune order dated 4th July 2023 issued by the DDSC Upper Subansiri Dapurizha. So, para. Though the case set up by the petitioner has been contested by the state, you have also filed affidavit.
No,
Okay.
I have.
Record.
All right. Though the case set up by the petitioner has been contested by the respondent number 5 by filing a detailed counter affidavit.
Respondent number 4.
Not
5. 4.
Okay, has been contested by the respondent number 4 by filing a detailed counter affidavit. Yet, in view of the specific contention raised by the petitioner as regards the non-possession of the B.Ed degree by the respondent number 4 to enable him to discharge the duty of residential school coordinator. The original record from the department containing the service book of the respondent number 4 was requisitioned by this court to ascertain as to whether the respondent number 4 did possess B.Ed degree. B.Ed degree at the time the Impune order dated 4th July 2023 was issued by the DDSC Upper Subansiri District, Dapurizha staff. As directed, the Mr. T. Jamal, Learner Standing Counsel for the Education Department, has produced the records in original which contains the service book of the petitioner. You have seen and show it to Mr. Garam. It's enough. Containing the service book of the respondent number 4. First off, on perusal thereof, it is noticed that though the respondent number 4 had completed his B degree since 2017. 2017 the on perusal of the records thereof, it is noticed that though the respondent number 4 possesses the degree of B since 2017, however, the said fact was not reflected in the service book of the respondent number 4 until 4th August 2023, on which date an entry was made in the service book of the petitioner that the petitioner is, the respondent number 4
has completed the teachers and college graduate in BA in year 2017. Only that much.
that the respondent number 4 has completed teachers training in BEd.
Examination.
Okay, just the respondent number 4 had completed BEd degree in the year 2017 from the Rajiv Gandhi University.
Yes,
From the Rajiv Gandhi University. So, from the above,
apart from that, my lord, on 20 April 2018, the DDSE, Dapodio has forwarded this certificate, BEd certificate to this
When?
elementary education.
when?
On 20 April 2018. my lord. 20 April 2018.
No, but
It's still they did in the internet.
but nothing reached service book.
My lord, no.
That's enough. From the above, it is thus evident that on 4th of July 2023, when the respondent number 3, the DDSC Daporism had issued the Tribune order dated 4th July 2023, assigning the respondent number 4 the duty of residential school coordinator. There was no material in the service book of the petitioner that the respondent number 4 possesses the BEd degree. If BEd degree is one of the requirements for assigning the duty of residential school coordinator in terms of clause 12 of the 9th Executive Committee meeting of SSA Rajya Mission Society, Arunachal Pradesh, held on 22nd November 2011 at CS Conference Hall, Itanagar. The respondent number 3, the DDSC Apostle Sri Daporism, could not have assigned the duty of residential school coordinator to the respondent number 4 by the imperial order dated 4th July 2023. So, in view of the above, what your submission?
In fact, also the quality of time. In fact, the engagement of the additional coordinator loss is for the basis of the analysis given by the other.
Just a moment, before, that, where I said, that, respondent number 4 has contested the case by filing a detailed counter affidavit, no? Then you say, respondent number 4 has contested the case by filing a counter affidavit. Where is, comma, in paragraphs 4 to 16, it has been contended as under, which are reproduced here in below. You reproduce the paragraph 4 to of the 16. Then, in view of the above, in view of the above findings recorded here in above, this court has no option but to interfere with the impugned order dated 4th July 2023, issued by the Director, DDSC Upper Subansiri, the police of byte number so and so. Assigning the respondent number 4 duty of the residential school coordinator being on the ground that the same has been issued in violation of clause 12 of the 9th Executive Committee, etc. 22nd November. So, the order dated 4th July 2023, issued by DDSC Upper Subansiri, the by number so and so. Insofar it assigns the respondent number 4 the duty of residential school coordinator is accordingly hereby set aside and quashed. The petition is still disposed of.
Highly obliged.
With above doubts. Liberty. That is always with them.
That is always with them. My lord, respondent number 4 should be thankful to me. Because of me, his at least BA degree certificate has come on record now. Highly obliged.
Yes.
My lord. I'm appearing on the behalf of SK Theory. Matter may be adjourned for today.
Matter has become infructuous. Okay. What is the matter?
After the construction and development of the now this gentleman came up with saying that this land has not been acquired.
Okay, all right. On the prayer of Ms. D. Rilu, then the council on behalf of SK Theory.
SK Theory,
And the council for the petition are listed after 4 weeks.
3 weeks.
Huh?
After 4 weeks.
4 weeks, 4 weeks.
Much of this.